We have a number of different programs, a court watch program where we train observers for arraignments. We have community workshop programs on various topics such as court basics, criminal law, landlord-tenant law, just to name a few, which we present to libraries, community organizations, schools. We can provide these workshops to your organizations as well. Additionally, while PMC supports the merit selection of appellate court judges, the current system in Pennsylvania is elections. This is an election year for judges, and PMC wants to make sure Pennsylvania voters learn about the candidates and the courts for which they are running. We therefore host candidate forums to showcase the candidates and enable people to make informed decisions. We are hosting one such forum virtually on September 20th for all the candidates for Pennsylvania's appellate courts. And as you are aware, we host one-day law school for journalists to help journalists, the press, and the media understand the court system on which they are reporting. Lawyers have difficulties understanding the complexities of the legal system and court cases, and they have at least 3 years of training. We hope to provide you with some basic information in order to inform your reporting and give you the tools to ask questions and seek answers. Courts address issues affecting so many aspects of our lives: employment rights, civil rights, family disputes, commercial and business disputes, housing rights, just to name some. Journalists and reporters are the firewall of our democracy. While judges are limited by their code of conduct from publicly speaking out about pending matters in cases and issues before them, you, the press, can shine a light on their decisions and on court proceedings. Both judges and the press hold unique positions among our democratic institutions. The independence of both and the freedom from undue influences are the cornerstone of a democratic society and safeguards for the freedoms and rights of the citizens. Both the press and the judiciary faced challenging times during the past 4 years, but nevertheless, I truly believe both institutions are stronger and as a result have encouraged increased citizen participation and interest in our democracy. We have an amazing program planned today and over 200 participants have registered. As a result of this terrific interest, all participants will be muted. However, we want you to ask questions. So please put them in the chat feature and we will do our best to get to them. The program will be recorded and available for review on our website. You will also be sent a follow-up survey to complete. Your feedback is very much appreciated and used for future programming. We will begin with the keynote and interview of Cherry Gregg, followed by a panel addressing the grand jury process, which is particularly timely, a panel on the Right to Know Act and transparency, and concluding with a panel on hot topics affecting the press. We are truly appreciative of all these individuals who have agreed to speak today. Without further ado, I would like to introduce Cherry Gregg. She is an extremely accomplished attorney and journalist who recently joined WHYY as an on-air afternoon host. I enjoy listening to you. Yesterday, I heard you ask people to tweet you about their vaccinations. I thought it was wonderful. She's a past president of the Philadelphia Association of Black Journalists, the recipient of 2 Edward R. Murrow Awards, and has a deep passion for community outreach. She is a huge supporter of many of our legal nonprofit organizations in Philadelphia. Cherry, welcome and thank you.
Thank you so much, Debbie, for that wonderful introduction. And thank you for Pennsylvanians for Modern Courts for having today. This is so important for journalists to have access to this type of information so that we can do our jobs better. I want to take a quick poll from everybody who's here. Welcome, everybody. Put in your chat if you are a working journalist, say I'm a working journalist. If you are a student hoping to become a working journalist, put that in there. If you're an attorney, put that in there. You know, maybe you write too and you want to see what we do. Put that in the chat. Light that chat up. I want to see who I'm talking to today. A lot of working journalists in there, student journalists. Yes, are you going to be behind the scenes? Will you have a byline? Put it in there and let me know, and feel free to put your comments in there. As Debbie mentioned, my name is Cherry Gregg. I'm a journalist. I'm an attorney. I've worked in radio for 10 years, just celebrated my 10th anniversary in January. I've covered public policy, civil rights, race, criminal justice. That has been my background. But I have certain reasons. The same reason I went to law school, Howard Law, by the way, any Howard Law grads here, shout out to the Bison in the virtual room. The same reason why I went to law school is the same reason why I went to J school. The US Constitution. Also the Bill of Rights, the 1st, 4th, 5th, 6th, 8th, 13th, 14th, 15th, and 19th Amendments, my favorite, right? I saw my job as a lawyer is to work to make sure that this democracy, to protect this democracy, and I see my role as a journalist to do the same. I actually see journalism as a very noble profession. It's one of the only, I think, mentioned in the actual US Constitution. Press, specifically mentioned in the First Amendment. And there is no democracy without the press, because we inform the people so that they can govern themselves. We also act as watchdogs to ensure that the government is doing what is promised and it's not overstepping its bounds. But the courts, the third branch of government, the arbiter of our rights, of these laws of our union, is vital to the democracy. And understanding how these courts work is vital in order for us to do the job. I want y'all to put in the chat right now, tell me, when was the last time you took a civics course? All you journalists out there, when's the last time somebody broke down like the structure of the courts? A lot of times it's only one little class that you took in high school. Maybe if you studied political science or something in college, maybe you got a crash course in it. So it's okay if you don't know. That's why you're here today. Know what you don't know and try to educate yourself. So I want you to also put in the chat, name a story that you remember in recent days, and there's a lot of them, where the courts were directly impacted. Light the chat up. Tell me, a recent case, and I can just throw it out. Bill Cosby. Courts, right? Voting rights, all up in the courts, okay? George Floyd, court case. Remember OJ? Okay, I remember OJ and that white, we were all glued to our television watching that. Other court issues. We're talking about Roe v. Wade. Everybody's constantly watching, seeing what the court is going to do, with regard to women's reproductive rights. All of these things are issues that our courts take a look at. And so what is our role in all of this if we're journalists? We as journalists many times uncover wrongdoings. We use the courts to get access to information, and we translate, right, court decisions that are made. But we have to understand how things go. I want to shout out Mary Claire Dale. She's a courts reporter for the Associated Press. Did you guys know that she was the reason that the public got to see Bill Cosby's deposition in the Andrea Constand case? She actually petitioned to unseal that deposition. And while, now Bill Cosby is a free man, right? She gave validity to the claims of dozens of victims in that case. And so this was a journalist who actually used her power as a member of the press, as a member of the public, to get access to information and reveal that information to the public. So if you feel free to use the chat during my discussion with Debbie. I'm going to stop talking now. And we're going to hone into some things, but I just wanted to kind of give you an overview of how we as journalists work to showcase what our courts are doing in other branches of the government as well.
Thank you. So how do you think non-lawyers should learn about the legal system and process? Like what do you do when you hear about a case that you're interested in, like how do you find out about the case besides going into court?
Well, the first thing I did, because every state is different and every county is a little bit different. And so one of the things I always do is go on the website of whatever court to kind of figure out what information is available. There's a lot of, depending on the county, depending on the state, whether it's federal, state, county, whatever, you can get access to certain information. So I'll always check out the website, the court website, see what types of databases are available to access information, what is free, what isn't free. I'm not afraid to call the clerk, and find out what I can have access to. A lot of times I'll get access to briefs. We always have PACER accounts if it's federal. So I'll pull some briefs, the original complaint, whatever documents that I think would help me better understand a case. And I just think I just do the work, understand how a specific state or is structured. What's the highest court? How does the appellate process court? Because the courts are called different things. Yeah. And I think people get confused and hung up on the names. Like we have Superior Court here in Pennsylvania. That's not something they had in Georgia, another state that I'm barred in. And so you kind of have to acclimate yourself to how it works. We're also a Commonwealth. So we have Commonwealth Court, and what court, when we were doing voter ID, everything was in Commonwealth Court, right? Right. So, you have to kind of understand which courts have served different functions. And one of the ways to do that is very basic on the websites and making those phone calls.
You had told me a story about how you were asked to follow a matter in bankruptcy court. Mm-hmm. And you knew nothing about bankruptcy law, because bankruptcy law is really an entity unto itself. What did you do to learn about bankruptcy law? Because it's also complicated.
Oh, it's very complicated. First of all, people think that just because you're an attorney, you know everything. And shout out to all my lawyers here. We do not. We're very, skilled in our area of law, but other areas we have to become competent. So that's what I had to do. I called a friend of mine who was a bankruptcy lawyer, and I literally, Debbie, was in the bathroom on a break with my little notepad like this, right, with the acronyms, and asked, what did this mean? And he actually sent me like a little primer on some of the information. And I was covering the Hahnemann Hospital bankruptcy proceedings, which was very important to the public, but I had to explain in layman's terms, okay, what that meant. And that's our job, to translate these difficult, complicated concepts so that I say someone with an 8th grade education can understand what happened.
Do you ever reach out to any of the area bar associations or law schools or professors, to help you with learn about the underlying facts or law?
Absolutely. I mean, the Philadelphia Bar Association has been a great friend to me. I think over time, though, as I covered criminal justice reform for about 8 or 9 years, I just started to learn, because I was never a criminal defense lawyer. I did some forfeiture cases, but my practice area was intellectual property litigation. So I had to learn criminal law, and I knew a lot of lawyers in that area. And over time, you just pick it up and you understand how the systems work. And so that's basically what I did. But yeah, I have professors on speed dial. I have lawyer friends on speed dial. And I just, learn. I've done CLEs on areas because to keep, but you can take classes and courses. And I know even if you're a journalist, there are conferences that you can go to where these types of things are explained. You have to constantly be learning.
Yeah, I know that, so PMC is frequently contacted by the press. And then a few years earlier, I was chancellor of the Philadelphia Bar Association, and the Bar Association was always being asked, about to comment or for referral sources. So it's really, and I've never known anybody to say no when you make an ask. So, this past year has been particularly challenging, I would think, for reporters covering the courts, because the courts have not been open. So, can you tell any stories about any particular challenges that you have encountered in this past year?
Well, one of the difficulties was, first of all, lots of postponements. So things that you would normally be covering, getting kicked down the road, a lot of uncertainty and getting access to links. You had to make friends, right? And Debbie, I think we talked about this a few days ago. You have to have contacts. You have to make friends, not when you need them, but so that you can access certain things when things shift and that people will explain to you what's going on. I also had to part of it was, the story was that about the courts itself, gaining access to the court. So normally your job is to simply just show up to a hearing, but now it's changing whether or not there is a hearing and when there will be hearing and how you will have access to court. So that was a story in and of itself. I think some of the stories that I covered was some of these folks who just were languishing without justice. So it also became a story, what the impact that it has on people, average defendant. You're waiting for weeks and weeks and months for justice. And some people have been waiting a year now to get justice because of the backlog. And the backlog is now a story.
And the backlog, it's the courts are really pulled and put in a difficult position because, with criminal law, they have to address, give people a trial and hearings prior to civil cases. So it's really hard, and the judges don't have that many hours in a day for a trial, or hearing, so it's really challenging. It's funny you said that. I went online yesterday to look at the Elon Musk trial in Delaware to see if I could look at some of the briefs, and there was a 20-page alert to the media from the court as to how you can find out about the case, how you can listen, what information you need. It was very impressive. So I think the judges too, as the year progressed, became more comfortable opening up their courtroom virtually to reporters and to citizens to watch.
Yeah, I think so too, because they understood. And especially with cases with big public concern or public interest, the courts do pretty well. I know in Pennsylvania, they do exceptionally well, providing separate sections of the website with information that you can easily access. And I think they kept that up, even though the pandemic, slowed things down. So yeah, I think the courts are getting better, and they're becoming more accessible to us, Debbie.
I will caution, I guess, be careful how I ask this, but recently you mentioned the Cosby trial, but it actually surprised me to see that the Supreme Court Chief Justice Behr participated or gave an interview about the Cosby trial. And but I do think that, as you said, the courts feel this pressure to be, more accessible. And, and I wonder even if social media has had any impact, or if you think social media has had any impact on journalistic reporting.
I think social media, first of all, I follow all the courts. That's how we get quick access to opinions. SCOTUS blog they always tweet the U.S. Supreme Court decisions right when they come out. The Pennsylvania Supreme Court has a Twitter page, and they will tweet the decision. I have them actually sent to my phone, Debbie. That's how quick. And then as soon as it comes out, I'm on it, right? And you're able to get access to the opinion. You can put it on your Twitter. You can put it on your website. I also want to talk about this trend of judges speaking out, because I think it's because of Twitter that they speak out, and because of social media. If you remember, former President Donald Trump talked about Obama judges. And in 2018, U.S. Supreme Court Chief Justice John Roberts issued a rare statement in response to a journalist from the Associated Press, by the way. And he wrote, "We do not have Obama judges or Trump judges, Bush judges or Clinton judges." I don't know if y'all remember that, but you never would hear from a U.S. Supreme Court justice in such way. And since then, I mean, now you hear judges like Alito gave a speech that went viral, right?
Right.
And then you have Justice Breyer talking out against packing the court. Like, he's giving his opinion on what would happen. This was very recent, on packing the court. When does this happen? But they know that if left to their own devices, a story will spread on social media, and the judges, which are people, will be left to clean up the mess.
Yeah. So have you, I guess, have you seen any difference in the kind of reporting now that social media, is more active in covering the courts? Like, I'm curious as to whether, you're limited by words, and how do you really show an in-depth investigation of a legal matter when you have social media coverage?
I definitely think that's probably why this course is so packed, because and people don't realize how difficult it is. I've been working doing short stories for the past 10 years, because radio, a lot of times we got to do a minute, 2 minutes, very short stories, but it's hard. Okay, Debbie, it is hard to take a 15, 30-page opinion and crunch it down to 1 minute.
Right.
That is a skill in and of itself. And so how do you do that? And I think social media has forced everybody to up their game, because you really have to have a really good understanding of things in order to distill it into bites like that. I know I've started using Threads a lot more on Twitter, because sometimes one tweet is not enough. You need 10. So Threads help that. Also, the fact that you can screenshot now, portions of the opinion and just share that with people so people can interpret things on their own. So I do think that social media has changed the way we share information, people's access to information, how we interpret courts, as well as the court's response to this. But I think it forces journalists, like the many that are here today, and the journalists in training, emerging journalists, to do their work and to really learn how things work, so that we're not putting out inaccurate information. Because trust me, Twitter will point that out too if you get it wrong.
Well, both judges and journalists have unfortunately been attacked, over the past couple of years. And, I guess, do you feel any obligation or, duty really in your reporting to almost protect, the independence of the judiciary because of these a lot of unfounded attacks?
Absolutely. I do. Because journalists, just like we're people, judges are people. And I've heard about judges. There was a federal judge, I think her son was murdered.
Yes.
Yes, her son was murdered. They were attacked in their home. And I think that journalists have to be careful and understand that these are people on the other side of things. We want to make sure we get it right. And we have to leave personal opinions out. We give the facts, and remember that the judiciary is supposed to be independent. That's why they have lifetime appointments with regard to federal judges, so that they can deal with political issues without that type of repercussion and be fair. And so we as journalists have to be careful, just like we're careful with anybody, but especially with our courts, because if people don't trust the decisions, our democracy, it's severely weakened.
And judges are bound by interpreting the law, and while the facts that are presented in front of them in interpreting the law, right? So they can't make up they can't make up facts. They have to deal with what's in front of them. So
and I have to say, this whole Pennsylvania Supreme Court situation, lawyers and journalists talked about this Bill Cosby case differently than the public.
Right.
And it's our job to explain, while somebody may be, the facts may say one thing, there are legal processes that that must take place. You've got to protect somebody's constitutional rights, and that a lot of times it may seem like an outcome is not just, but it's legally sound. And so I think that we have to do our jobs in explaining the difference between public emotion and what the legal facts are.
And I agree with you. I think emotion gets sometimes heightened and out of, and makes the law lose perspective and understanding. We have about 1 minute left, but tell us about it. One of like your most interesting cases that you reported on, and why it was so interesting.
One of the cases that I followed from beginning to end, and that's what made it so interesting, was the voter ID law in Pennsylvania. It was the first big story that I covered as a journalist, and it made me very grateful that I went to law school. I watched the voter ID law in Pennsylvania become law, and then followed it through the entire system. So from it being a proposal, going to committee, passing into law, to then suffering, having the litigation, and then being overturned by the Pennsylvania Supreme Court just before the election that year. And so that was one of the most interesting situations I've ever worked on. I was breaking news the entire 2 years that I covered this matter, but I had to use every skill that I had. I got access, I had to use FOIA requests, right? I had to use everything I had in the arsenal in order to cover this from beginning to end. And it was something that was of public concern. It affected our most fundamental right to vote. And we had an election coming up. And so that, I think, that gave me a sense of, I need to do this right. I need to make sure I know what's going on. It made me learn the courts. It made me make contacts. And it was probably the best exercise in my career. And it sort of turned me into the journalist that I am now. That was a transformational period of my learning in this part of my career. So, yeah.
Well, thank you very much. This was terrific and a great way to start our morning. So I appreciate your time, and hopefully we'll reach out to you again and for another future program. So thank you very much.
For sure. And thank you, everybody, for being here, and good luck in your becoming, schooled in the courts. Thank you.
Okay. So I'd like to now turn it over to our first panel on the grand jury process. We have Michael Schwartz, Eli Siegel, and Jennifer Buck. And thank you all.
Good morning. I thought we could each spend a moment introducing ourselves, and then we'll cut right in. So I am Eli Siegel. I'm a partner at Troutman Pepper, the law firm. I'm based in Philadelphia. I'm the co-chair of our First Amendment and newsroom practice. So much of my practice is representing journalists, both in defending against lawsuits when journalists are sued for defamation and invasion of privacy, advising ahead of publication on risks that may be involved and how to achieve your goals as a journalist while mitigating whatever risk may be presented. And also in representing journalists who are trying to get access to information to write about in the first place. And I'd add on top of that, if journalists become subject of a subpoena, including in a grand jury context, I handle those issues as well. So I really love this work. I feel passionate about it. It's nice to do something for a job that feels mission driven and that I feel really strongly about. So happy to be here today. I'd like to turn it to Mike and then to Jennifer to introduce themselves, and then I'll get us kicked off.
Thanks, Eli, and thanks, Debbie. It's a pleasure, amazed to be in front of 100 folks virtually like this. My name is Mike Schwartz. I've been practicing law for about 30 years now, half of which I was a federal prosecutor in Philadelphia, and half of which I've been a private practicing lawyer. I'm a partner at Troutman Pepper, and my practice is a mix of white-collar criminal defense work, government investigations, and I second chair Eli, helping him with a number of media cases, especially when it involves criminal issues and grand jury issues. So I look forward to talking to you about the grand jury process.
Good morning, everyone. My name is Jennifer Buck. I'm Senior Deputy Attorney General with the Pennsylvania Office of Attorney General. I've been with the office approximately 14 years. I handle appellate litigation in state and federal courts in connection with capital and non-capital cases. But primarily for the past 5 years, my main responsibility has been to supervise our statewide investigating grand juries. Prior to joining the Office of Attorney General, I had worked as a prosecutor with the Bucks County District Attorney's Office for 6 years, where I also handled grand jury matters. It's a pleasure to be here this morning.
So just a quick overview of the structure of what we're going to be doing. So Jennifer is going to start and talk about the state grand jury process. And then Mike's going to talk about the federal grand jury process. And then we're going to turn to a discussion on sort of what this means for you as journalists, focusing on two issues. One is about getting access to information about grand jury proceedings. And then sort of what happens if you find yourself on the other end of a subpoena, a request to be a witness or provide documents in the course of a grand jury proceeding. So I'll turn it back to Jennifer.
Thank you. In terms of the investigating grand jury, there are two central purposes for it. First is to investigate crimes where traditional law enforcement methods have proven unsuccessful. What I mean by that is as follows. For example, there's a shooting on a street corner in broad daylight. Lots of people around. However, when the police go out and start knocking on doors, no one heard anything, no one saw anything. The police are not able to advance their investigation. People are fearful of retaliation. Maybe they're just reluctant to cooperate in general, or perhaps they're mistrustful of police. So without the information from the witnesses to the particular crime, the case cannot be solved. So that would be a type of case that would get submitted to a grand jury, because one of the grand jury's incredible powers is the ability to compel testimony in the appearance of witnesses. So in this particular circumstance, the individuals would receive a subpoena to come before the grand jury and testify in secret about what they saw or heard in connection with the shooting. Rather than their neighbors seeing them talking to the police, they feel much more safer in that regard. The other primary focus and purpose of a statewide urban investigating grand jury is to protect our citizens from unwarranted criminal charges. A beautiful thing about the investigating grand jury is it's very different from a trial jury where you're just sitting and listening and then deciding guilty or not guilty. These jurors are actually becoming investigators. They are going to determine whether or not someone should be charged with a crime. So that's an incredible responsibility that they have. And we'll be talking about grand jury secrecy in more detail here as we move through the presentation. But for those individuals who the grand jury investigates and decides not to recommend charges for, the grand jury secrecy component is critical in that regard. Because if the public had learned that a particular individual was under investigation, and then the grand jury decided not to recommend charges, their reputation would be ruined. So grand jury secrecy in regard to protecting reputations as well. There are two types of investigating grand juries in Pennsylvania. We have the county investigating grand jury as well as statewide investigating grand juries. Not every county in Pennsylvania has a grand jury. There are only a certain number of them that do. The grand jury that I'm going to be talking about this morning is the statewide investigating grand jury. We presently have grand juries that sit in Norristown that hear cases from the Eastern District of Pennsylvania, a grand jury that sits in Harrisburg, receiving evidence in connection with cases involving the central part of the state, as well as an investigating grand jury in Pittsburgh, which hears cases from the Western District of Pennsylvania. So how does the process get started? In order to impanel a statewide investigating grand jury, the Attorney General of Pennsylvania must make an application to the Supreme Court. In that application, he must aver that there are cases involving organized crime, public corruption, or both that span multiple counties of the Commonwealth. Once that application is presented, the Chief Justice of the Supreme Court has 10 days to review the application and issue an order either granting or denying the application. I would note that unlike most grand jury documents, these two particular items, the application and the order, are both public. So they are publicly available for review. In the order approving a statewide investigating grand jury, the Chief Justice will designate a supervising judge for that particular grand jury. And at that point, he will further direct the state court administrator to select 6 counties, in addition to the county where the grand jury sits. So for example, the Harrisburg grand jury sits in Dauphin County. So he would direct the court administrator to select 6 counties, in addition to Dauphin, to supply prospective jurors for the new statewide investigating grand jurors. And the number of jurors assigned to each county is based on population. So again, it's a random selection of these 6 other counties, and the number of jurors to be selected is based upon population. Once that process has been completed, the supervising judge and myself, we visit the different counties to select jurors for potential service. The jurors are summoned in the same way as they would be for normal county service for a trial jury. It's the same qualifications. So we go to the counties and explain to them the purpose of the selection process is to be a potential juror for a statewide investigating grand jury. And then we let them know that the statewide investigating grand jury sits for 18 months with the possibility to extend to 24 months if a majority of the jurors determine that their business has not been completed. So there's a lot of hesitation, trepidation when our jurors hear that when we come to visit them in the counties. The grand jury sits 1 week a month, so not the entire 18 to 24 months, but 1 week a month in this particular case in Harrisburg, where they will be working on a variety of cases. So the total number of jurors that we select from the 7 counties is 200. Once those 200 jurors are selected, we provide those names to the state court administrator, and 50 jurors are randomly selected to report to Harrisburg for the impanelment of the new grand jury, which is the beginning of the process. From that 50 on the impanelment day, the supervising judge selects 23 permanent members and 7 to 15 alternate members for a maximum of 38. So even if they're one of the final 50, that doesn't necessarily mean that they're going to be a member of the statewide investigating grand jury. So there's a maximum selection of 38. And in terms of what permanent jurors can do versus alternates, the distinction there is that permanent members actually get to vote. So before a presentment is given to them, which I will explain in more detail a little bit later, the majority of the grand jury has to vote as to whether they would wish us to prepare one for their consideration. If there is a grand jury report, only the permanent members can vote with respect to whether that should be issued. The alternates sit and listen to all of the evidence that is presented on the cases. They're allowed to ask questions. However, they simply cannot vote. That's the distinction between permanent and alternate members. And the reason that we pick such a large number of alternates is, as you can imagine, 18 to 24 months is a long time. There's a lot of life changes that some people may go through. They may get a job out of state. They may go off to college. So if we lose a permanent member, the next alternate in line, so if we had not used any alternates yet to replace a permanent, alternate juror number 1 would step into the shoes of the permanent juror that he or she replaced, and then would be able to vote along with the permanent jurors. With respect to how a case is submitted to a grand jury, the document that formally introduces a case to the grand jury is called a notice of submission. That document generally describes the investigation as well as the resources of the grand jury that are necessary. That document is presented to the supervising judge for his or her review. Once signed, it is then given to the jurors, and they keep all of the notices in a binder where they keep their notes with respect to each investigation. As I mentioned earlier, one of the incredible powers of the grand jury is the ability to compel testimony of people, to compel their appearance. Another incredible power is the power to subpoena documents and records. That could be anything from bank records to telephone records to Facebook records. We've received an incredible amount of evidence through issuing subpoenas to Facebook and Instagram, where people have either been talking about crimes that they committed or posting pictures of themselves with the fruit of crimes. So that's often a type of document that the grand jury will issue a subpoena for. With respect to the daily operations of the grand jury, once the witnesses arrive in the morning, he or she goes before the supervising judge to receive what's called the colloquy. During that colloquy, the judge advises the witness of his or her rights and obligations as a witness before the statewide investigating grand jury. The first right that they're advised of is their right to counsel. Secondly, they're advised that they have the right to refuse to answer any question which they believe may tend to incriminate them. And third, they're instructed that they can share their testimony with whomever they choose if they choose. This is very different from the other participants in the grand jury process. Attorneys, jurors, interpreters, stenographer, all of those individuals are sworn to secrecy. Witnesses are not. They are free to disclose their testimony with whomever they choose, if they choose to do so. With respect to counsel for a witness, if a witness brings a counsel with him or her to the grand jury, the counsel fills out what's called the entry of appearance and secrecy oath for counsel form. So that serves two purposes. First, obviously, is to indicate who they are representing. This is an important distinction in the case where we have an investigation into a corporation. So it's necessary to determine whether or not the counsel is appearing on behalf of the corporation itself, or perhaps some of the individual employees. With respect to the secrecy oath for counsel portion of this form, as I mentioned, attorneys are sworn to secrecy. However, if an attorney receives the authorization of their client and there is no court order to the contrary, the attorney is free to share his client's testimony to the same extent that the client is. But again, it needs the client's authorization, and there cannot be any court order to the contrary. And by court order to the contrary, I'm talking about an order for non-disclosure of testimony. As I mentioned, witnesses are specifically told during the colloquy that they're permitted to share their testimony with whomever they choose, if they choose to do so. However, the next part of the colloquy advises them that if there is good cause shown before the court, there may be an order instructing them that they cannot disclose their testimony. So I would say that those orders for non-disclosure of testimony are the exception rather than the rule in terms of statewide investigating grand jury practice. If an attorney is concerned, or an attorney and investigator are concerned about perhaps witness intimidation or retaliation or destruction of evidence, there might be an application made to the supervising judge to issue the witnesses not to disclose their testimony before the grand jury. That's a formal hearing that's held before the court. The judge will ask questions, make findings, and then ultimately determine whether or not to grant that order of non-disclosure. If the order is granted, when the witness is brought in before the judge in that particular case, the judge will ask the attorney for the Commonwealth to read in the order of non-disclosure at that time. There is a provision that if the counsel for the witness seeks to challenge that order, the counsel can obviously make an application to the supervising judge to do that. As far as the supervising judge, unlike a regular trial, he or she is not present in the courtroom during the testimony of the witnesses. The only individuals who are in the courtroom are obviously the witness himself or herself. Different from federal court, the witness can bring their attorney with them into the courtroom. Now, this attorney is not permitted to make any arguments or objections or otherwise interject into the process, but they are available to be in the room with their witness in the event that the witness wishes to consult with them. If the witness is concerned about a particular question or wishes to consult with counsel, all the witness needs to do is advise the prosecutor that they would like to speak to their attorney. They step from the room and have a discussion and come back in. So that's normally how that works. But the judge is not present in the room. If there becomes a situation where a witness hears a question and believes that the answer may tend to incriminate him or her, at that point, the questioning of the witness would stop. The witness would go before the supervising judge. And what would happen would be the prosecutor would advise the judge of the question that was asked of the witness. The prosecutor would step from the room and the judge would have a discussion with the witness and decide whether or not he or she needs to answer that particular question. The prosecutor is not privy to that conversation. All the prosecutor learns at the end is whether or not they can go back into the courtroom and ask the question, or whether they need to move on from that particular line of inquiry. The jurors can ask questions of the witness. Now, not directly. The process is, once the attorney for the Commonwealth has completed questioning, the witness steps from the room and the prosecutor turns to the grand jury and says, "Do you have any questions that you would like me to ask of this particular witness?" And that's the chance for the jurors to get involved and really mold and shape these investigations, because sometimes based on perhaps their employment or just prior life experience, they see a particular angle of a case that the prosecutor and investigator had never even thought of. You know, oftentimes we might get tunnel vision looking at a case in a certain way, So really the input of the grand jurors is essential to the functioning of the investigating grand jury. Sometimes the prosecutor may not ask a question that a grand juror would like. A situation may be perhaps we have a drug investigation where a girlfriend of one of the main suspects decides she's going to cooperate, but doesn't want her boyfriend to know. So she comes in and testifies and gives all kinds of information and evidence. And then the next session, the boyfriend comes in. And after the completion of his testimony, the juror may say, well, the girlfriend told us X, Y, and Z last month. Why don't you ask him those questions? And the prosecutor will say, well, if I ask him those questions, that's only information that the two of them knew. So by asking those questions, he would probably know that she was the one that came in here to provide that information, and that could jeopardize her safety. So there may be situations where a question may not be appropriate. Sometimes they may have a question and the prosecutor may say, you know, excellent question, definitely relevant, but we have a witness coming in after this that's better prepared and equipped to answer that for you. So it's very much a dynamic, interactive process in that regard. The grand jury can have discussions with the prosecutor about witnesses that they would like to hear from, as well as documents or records that they may like to review. At the conclusion of the investigation, once all the evidence and testimony has been completed, the prosecutor goes before the grand jury and asks whether the grand jury would like a presentment prepared for their consideration and review. And the presentment is a summary of the evidence that was received by the grand jury, as well as a recommendation of charges. So that's the first step. Sometimes the jurors say after a vote, no, there's not enough evidence here. We do not want to consider a presentment. Other times they say, yes, please start the process of preparing a presentment. Once that presentment is given to the jurors, they have the ability to change, correct, amend that document as they deem appropriate. The presentment is read to them. The prosecutor, the court reporter, and the alternates then all leave the room so that the permanent members can begin their discussions and their deliberations on the particular presentment. In order to conduct business on any given day, we have to have 15 permanent members present. But in order for a presentment to be approved, we only need a majority of the permanent members, or 12. So those permanent members begin their discussions and deliberations in connection with the presentment. They are instructed on the law and the elements of all of the offenses. Sometimes they'll ask for the instruction again. Other times they may ask to review a transcript from a particular witness, or they may ask to review a particular exhibit that was shown. So the transcripts and exhibits are all readily available for their review during the course of their deliberations. Once they have completed those deliberations, the foreperson signs the presentment, and the foreperson is sort of the leader of the grand jury. He or she is responsible each morning for confirming that we have a quorum or 15 permanent members present. If there are questions during the course of deliberations, he or she collects those questions and provides them to the prosecutor, and otherwise orderly facilitates deliberations to make sure things don't get too heated. We also have a secretary who's an officer of the grand jury, and he or she is responsible for taking attendance each day and making sure that we're not missing any jurors that are supposed to be there that are unaccounted for. So once the presentment is approved by the grand jury, the next step is for it to be presented to the supervising judge for his or her review. Once signed, the next step in the process is for the prosecutor to prepare formal charges. And that's the filing of the criminal complaint. And there's an affidavit of probable cause that is prepared by the lead investigator in the case, who describes the involvement in the investigation, that they've been present for the grand jury sessions, have reviewed the presentment, believe that it contains accurate information, and believes that there's probable cause to arrest the individual or individuals that are listed in the presentment by the grand jury. So the presentment itself at that point is attached to the investigator's affidavit of probable cause, and it's filed publicly. So at that point, it follows the traditional route in the state system where the charges are filed, there's a preliminary arraignment, and then the next step is a preliminary hearing. And that's the opportunity to test the evidence to make sure that a crime has been committed and it's likely that this is the individual who committed it, which is a prima facie standard. So if the magisterial district judge holds the case for trial, it would then proceed to the Court of Common Pleas. So that's the process that the presentment the presentment follows. If there are any challenges during the course of a grand jury investigation, perhaps an attorney has filed a motion to quash a subpoena as being overly broad. Perhaps the Commonwealth has a challenge because they believe that an attorney's representation of multiple witnesses constitutes a conflict of interest. Those are common issues that arise during the course of grand jury investigations. They're first litigated before the supervising judge, and then ultimately the next step, if there's an appeal taken, it's to the Supreme Court of Pennsylvania. It doesn't follow through any other appellate intermediary courts. It automatically goes to the Supreme Court of Pennsylvania. It's assigned a miscellaneous docket number, and usually they try to fast track those cases a bit, knowing that there's time limits to these grand jury investigations. As I mentioned earlier, grand juries only sit 18 months with a maximum of 24 months if the majority of the jurors determine that their work has not been concluded. I believe that's all I have on the statewide investigating grand jury process. I will now turn it over to Mr. Schwartz to discuss the federal side.
Thanks, Jennifer. And Jennifer gave a great overview of state criminal law. And remember, the state has primary responsibility for investigating and prosecuting most crimes, most violent crimes, most drug crimes, fraud, and other types of crimes. And the federal authorities have much more limited power to investigate and prosecute crimes, but sometimes they become the high-profile crimes. Starting point. Sherry had said it before. I always go back to, I don't know if this is coming through, my National Constitution Center copy of the Constitution. And I teach at Temple Law School various classes, so I always like to start with first principles. And where we're going to start is the Fifth Amendment to the Constitution. Everybody thinks of Fifth Amendment, I plead the Fifth, I'm not going to cooperate. We'll talk about that a little bit. But the beginning of the Fifth Amendment says that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Federal criminal law is different than state law. Jennifer described how they could use a statewide grand jury to investigate and prosecute certain crimes. But probably the large majority of state crimes never go to a grand jury. The police see a crime or investigate a crime, they arrest someone, they go to a proper magisterial district justice or municipal court judge, they get a warrant based on probable cause, and the state criminal process starts. On the other hand, in federal law, the majority of cases come through a grand jury initially. The grand jury hears evidence and decides whether there's probable cause to believe a crime has been committed. So unlike what Jennifer just talked about of a preliminary hearing to test the charges, in federal criminal cases, if an indictment is returned, there is probable cause and there's no preliminary hearing to test it. The indictment is presumed to have established the probable cause for the crime. Now, you saw capital crimes. Very rarely are there federal capital crimes that are prosecuted. The feds generally allow state-level prosecutors to prosecute homicide and other types of capital crimes, although, you know, Timothy McVeigh and others are those exceptions. Infamous crimes means every single federal felony. Every crime that's punishable by more than 1 year. That doesn't mean that the person will be sentenced to more than 1 year, but if they're punishable by more than 1 year, then it has to go before a grand jury. The grand jury in the federal system is slightly different. There are 5 regular grand juries that sit in the Eastern District of Pennsylvania almost every day of the week. And those grand jurors hear multiple cases every single day. They do sit like the state system for between 18 months to 24 months. The term is 18 months, but they're routinely extended. And they sit 1 day a week, every week. So you do have a lot of grand jurors saying, I have an excuse, I can't do this. And the law allows both for alternates, but also says that the normal grand jury is impaneled of 23 people, but only 16 people have to show up for it to conduct business that day. And because the presumption is it's a 23-person grand jury, to be able to charge someone, to be able to return an indictment, there needs to be 12 grand jurors voting that there's probable cause. Now, some of you probably heard the old adage that a grand jury will indict a ham sandwich. I can tell you from my prosecutor days, that's not completely true. Jennifer already described the process. It is not an adversarial process where a defense lawyer, like what I do now, gets to test the government's evidence. The government gets to present the evidence, but the grand jurors in the federal system actually get to ask their own questions, sometimes directly of the witnesses. And sometimes the grand jurors say, I don't think there's enough evidence. So they do serve what is the constitutional role of protecting the citizen from the government bringing the charge, but they don't hear both sides of the story. There is a secrecy requirement. Again, just like the state, the secrecy does not apply to witnesses ordinarily. Generally, the people who are not allowed to talk about grand jury matters are the prosecutors, the grand jurors, the agents, folks that are privy to the investigative aspect. But especially for the section we're going to talk about later that directly impacts you as reporters, witnesses and their lawyers are allowed to talk to you and allowed to talk to anyone. And that's why oftentimes you're aware and the press is able to publish a grand jury investigation before it reaches its conclusion. It is the exceptional and extraordinary case that Jennifer or one of her colleagues, I know Jennifer would never, but it is extraordinary when there's a leak from a public official who's sworn to secrecy. That's a crime. And as we know from the Kathleen Kane case, it is a crime that's prosecutable and can lead people to prison. But on the other hand, defense lawyers and witnesses, for all kinds of reasons, political, interest, sometimes strategic, will be willing to talk to reporters, and that's perfectly allowed. One big difference in the federal system, I already mentioned it, is every felony has to go through the grand jury. Well, what happens when there's a bank robbery and the FBI and the police capture the robber that day? They don't run down to the grand jury to get an indictment that day. Under the federal system, people can be arrested on what's called a complaint and warrant signed by a U.S. magistrate judge based on an affidavit of probable cause. And then they must have their case presented to the grand jury within 30 days, unless people agree to more time. In those cases, there's not going to be a whole lot of witnesses brought to the grand jury. It probably is going to be one law enforcement officer who's going to describe the whole investigation. So when you're reporting and thinking about the grand jury process, not like a trial where each witness has to testify from personal knowledge, oftentimes it's someone summarizing their investigation. and the grand jury is allowed to hear hearsay evidence. It doesn't have to be firsthand. It can be from anyone who is willing to swear that this information is true, not only based on their information, but their personal knowledge, but on information and belief. And that's why a law enforcement officer can summarize the case. I've already mentioned a couple differences between federal and state, but here are some of the biggest ones. In the federal grand jury, no one's allowed in but the witness and the lawyer for the government and the grand jurors and the stenographer. So me as a defense lawyer is not allowed in. I'm allowed to sit outside. And if my client wants to consult with me, they actually have to stop the proceeding, ask to come out, and go back in. Now they're told they can do that, but who would think that in the middle of this tense proceeding done in secrecy with all these people watching, that the witness is really going to seek counsel? On the other hand, as Jennifer said, in a state proceeding where I've been an attorney for witnesses, while I'm not allowed to interrupt the proceeding, I am allowed to provide advice, and I literally am standing next to the shoulder of the witness. Eli's going to describe a little later on some practical representations of reporters, but one of the things I can tell you is I would often advise reporters when they can assert legal privileges in the middle of the grand jury proceeding. And that is a huge advantage in a state proceeding and a handicap in the federal proceeding. Also in the federal proceeding, you're not going to see a report or a presentment. Jennifer and her colleagues are allowed to not only charge someone and bring the evidence of the crime, but they can talk about all the evidence in the investigation, and I oftentimes will comment on process failures. Penn State's a great example with Jerry Sandusky. The Archdiocese is a great example where they talk about not only those who committed crimes, but also where processes have failed and recommendations to the legislature for potential improvements. The federal grand jury doesn't have that purpose. The federal grand jury is to return a charging document and not comment on policies or other failures. So that is a significant difference. Last thing I want to talk about for a minute, so we can get into kind of the meat of the reporters and that overlaps with it, is grand jury litigation. Jennifer mentions it, and we mention it to you because this is an opportunity for reporters to get insights while a grand jury is still going on. So what gets litigated? Jennifer mentioned in the state, and this also happens in the feds, that sometimes there will be a subpoena for documents that the defense lawyers may think are overbroad or improper. The defense lawyers have a right to challenge that subpoena. Now, the challenges and the filings often have to be made under seal to protect the secrecy of the investigation. But on the federal side, there is a docket that is created for every grand jury matter. And you can see certain entries in the docket. It doesn't have a lot of information, but it may give you leads as to who are witnesses' lawyers who may be willing to talk to you. What type of activity is going on in that investigation? So subpoena challenges are one issue. The other issue is privilege, and this is where it affects you. Oftentimes, especially for reporters, there are First Amendment privileges, there are shield laws and other privileges that Eli's going to mention in a minute, and sometimes they get litigated in front of the grand jury judge and appealed either to the state Supreme Court or on the federal side, to the grand jury judge, and then to the Court of Appeals here in Philadelphia would go to the Third Circuit. So those kind of litigations of privileges tell a lot about what's going on. I'll give you an example. Shaka Fatah, when the investigation was going on of then Congressman Fattah, there was issues about privileges under the speech and debate clause of the Constitution. Those privileges ultimately ended up in Third Circuit opinions that described how the government was able to get access to certain information and what information was privileged. So it is a window into what's going on. And the last, I'll mention two other pieces of litigation that would be helpful for you to understand. One is Jennifer mentioned early on, and this is an issue that came up in the Penn State Sandusky case, who is the lawyer representing? Is it an institutional lawyer or is it an individual lawyer? Sometimes, and especially in federal court grand jury matters, the prosecutor may challenge the lawyer's representation, alleging there's a conflict of interest. I may be representing both a corporation and its employees. And Jennifer or her federal prosecutor equivalent may say to me, Mike, the corporation's interest is different than the individual, and you have a conflict. Those issues get litigated, and for some of you, you may remember that was an issue in the FUMO grand jury, and that resulted in published opinions where the individuals' names were not listed, but for a good reporter who understands what's going on and following, many were able to report exactly what was happening and how that related to former State Senator Fumo. The last issue, Jennifer raised the issue in the state system that I don't like, and that is a grand jury judge testing whether a Fifth Amendment assertion is legitimate. In my world, and I go back to the Supreme Court's decision in Ohio versus Rainier, that is near and dear to my heart, that says the Fifth Amendment is designed to protect the innocent, ensnared in ambiguous circumstances. And the Fifth Amendment is not limited to the question, did I kill my spouse? But even the question of, do I know how to shoot a gun? Or where was I on a particular day? Those answers, even if I did not kill my spouse, could be used by a prosecutor to try to make a case against me. So in the federal system, generally, when a witness asserts their Fifth Amendment rights, they do so to every single question, and no one challenges the propriety of that assertion. With the exception, the prosecutor always has the opportunity, in both state and federal, to seek a court order of immunity. And if a witness is immunized, and this is important for reporters too, for those who remember Judith Miller, immunity requires you to testify. And if you fail to testify despite a grant of immunity, you could be put in jail for contempt until you decide to testify. So that's other types of litigation that would go before the grand jury. I could talk probably for another hour just on process, but Eli, how about if I turn it back to you to focus more on the reporters' issues?
Great. Thanks so much, Mike, and thank you, Jennifer. So now everybody here now sort of has a roadmap and at least an overview of how the state and federal grand jury processes work. And then the question is sort of what does that mean for you? So you can know all about it, but you want to find out what's happening in a particular case and try to find an angle in so that you can learn about a process that is traditionally and for good reason secret. And then there may be situations in which you find yourself ensnared in the situation, maybe in the ambiguous circumstances that Mike's talking about, maybe as a more tangential player. But I want to talk about some of the issues, both practically and legally, that you encounter there. So generally, court proceedings, courts are supposed to be open, right? As a reporter, a lot of information you get is by going on a docket. Sherry talked about this. There's information on websites. If a courtroom is sealed, you have the right to get a lawyer and go in and try to get it unsealed, because our foundational principle is that our justice system works best when it's all out in the public. And there's a First Amendment right and a common law right to get access to judicial records and judicial proceedings. That just doesn't apply in the grand jury context. No argument is going to be successful that the grand jury process shouldn't be secret, because that's how it's always worked. It facilitates its purpose, and that's never going to work. But that doesn't mean you throw up your hands and say there's nothing that I can possibly do to learn about the grand jury process. So I'm going to start, first I'll talk about information that you can get sort of through the courts, and then we'll turn to information that you can get from witnesses. So through the courts on the state side, and so this is going to be as a matter of statute instead of as a matter of, you know, constitutional right. Sometimes an investigating grand jury leads to the creation of a grand jury report. And these have been relatively high profile. And the statute sort of built into it says that the report is supposed to be filed as a public record, as long as it's based on facts received in the course of an investigation authorized by the Investigating Grand Jury Act. It's supported by the preponderance of the evidence, and its release wouldn't prejudice fair consideration of a pending criminal matter. So we had a grand jury report in the Kane matter. We had an investigating grand jury report in the Catholic Church situation. So a lot of information can be accessible to the public through that. The Catholic Church situation was interesting in that originally the report was filed under seal, and there was efforts to keep that under seal. And this is sort of a practical tip. We were faced with a situation where our clients really wanted to learn what was going on there. Again, this was an investigation into years and years of alleged misconduct within the Catholic Church dealing with sexual abuse. And we knew the challenges had been made to the release of the report based on the idea that some people who were mentioned in it thought that they didn't get enough of a shot to address the charges or the allegations that were made against them. We sort of thought about it and said, okay, we could file a motion and go for the whole thing, or we could try to present a reasonable solution. And we went with the reasonable solution, and recognizing that this was probably a 1,000-page report, and said, hey, here's the statute that says it should be made public. We recognize that there's some debate about some certain sections of it. How about releasing a redacted version of the report? And that played well, and that ended up leading to the release of 95% of the report, and left the litigation over the redactions to be a separate issue that was fought out by the parties that were really invested in that sort of narrow issue. So that led to the release of the report. Another thing that can become public, and Jennifer said usually does, is the presentment. Some situations, the presentment is not released, and you need to go in and ask the court. But again, the statute there says that the presentment should be released unless the defendant is in custody. Sorry, and the defendant needs to be, the presentment needs to be kept secret, but only until the defendant is in custody or has been released pending trial. So a very clear roadmap. And if we've had situations where it's sort of remained under seal, and just bringing this very simple argument to the court's attention has led to the release of the presentment. Then Mike talked about dockets. So if you have a docket number that you can get through various public documents, or perhaps through speaking with the witness, then you have information that you can enter into the PACER system. You can learn about motions that were filed. You can learn about attorneys. You can find for yourself some leads so you can actually get some more substantive information about an investigation. And then, as Mike said as well, at times there's briefing on issues where, you know, the secret stuff will be redacted or left out intentionally. But again, you'll learn about other people who you could then go ahead and talk to. So that's sort of what you can get through the court system. Then you turn to witnesses, where I think a lot of the information really comes from. And just to recap, on the federal and the state side, the government can't talk, grand jurors can't talk, court reporters and court employees can't talk, but witnesses and their attorneys generally can talk, and sometimes really want to talk. And I know there's situations in which a lot of substantive information has come out. Jennifer, I know you had sort of one that we had talked about before. I was wondering if you could share a little bit about that. I think you are on mute right now.
Sorry about that. So back in March of 2011, Sarah Ganim, who was working for the Patriot News at the time in Harrisburg, broke the story that Jerry Sandusky was being investigated by the grand jury. It was a bombshell newspaper article, obviously garnered national attention. And so the first presumption was that there must have been a leak, that someone had leaked this information to Sarah Ganim. But actually what's interesting part of this is, up until that point, the witnesses who were appearing before the grand jury, who had testified in connection with the Sandusky investigation, were free to disclose their testimony to whoever they choose, if they chose to do so. There was no gag order or order of non-disclosure at that point. But I think that that's a lot of times the initial reaction when information is shared with the media, that it's being done in an improper fashion, that it's being quote unquote leaked. But certainly, as Eli indicated, most of the time witnesses and attorneys can share the testimony if they want to share the testimony. So there are proper channels to get the information about an investigation to the media. And just because it reaches the media does not necessarily mean there is a presumption that some illegal activity had happened behind the scenes in terms of a juror or an attorney leaking the information.
Thanks. So that can come from a witness talking about their testimony and sort of what they've learned. Another very valuable source from a witness is a copy of a subpoena, because sometimes a subpoena will say, show up on this particular day and testify. But also, often a subpoena will also say, provide these documents. And there will be a list of many categories of documents. And you see the documents that are being requested, and you start to have a pretty good sense of what's being looked into. So, to me and reporters that we've worked with, that is often sort of the gold mine. And when you see reports breaking sort of news on a grand jury investigation, it's often based on a document subpoena that a third party has received and shared with the media. So you can have a company, you can have an individual, you can have a higher education institution, you could have a business, all sorts of people can receive document subpoenas. And if you find out about it and they want to share about it, again, there could be one category of documents. We've seen them where there's 20 categories of documents, and you've got yourself a great lead to start talking to people. And who the recipient of the subpoena was, and that they're there for you to talk to. Sometimes on the federal end, there will be a cover letter to the subpoena telling the recipient, don't talk about this. Don't tell anyone about this. I'd like to turn it to Mike to give some advice and practical sort of experience in terms of what this actually means.
So routinely, when a recipient, and you'll see this sometimes go into, Penn State, you may issue a right to know request or to a city government, and you'll see a cover of this cover letter, or people will see the cover letter, and it will say, please don't disclose this to your customer or to anyone else, because that could harm the grand jury investigation. Fair for the government to ask, but absent a court order, they cannot prohibit someone from disclosing. So where is there automatically court orders? In the federal system, banks are going to be sworn to secrecy. Telephone companies and some social media companies are going to be sworn to secrecy because routinely they can get court orders, or national security investigations could accompany a secrecy requirement. But otherwise, it's just a request. Now, be careful. That doesn't mean you can't go to people if your intent is to obstruct the investigation. Hey, by the way, the feds are investigating your investment in so-and-so company. Maybe you want to destroy all your records. That's a crime. That's obstruction of justice. But for a reporter that gets a subpoena and says, hey, member of Congress or state senator, I saw your name on a subpoena that was issued to the state pension fund. That's a fair question. Your intent is not to obstruct the investigation. In fact, your intent is to act in your proper role of shining a light on potential issues of concern. So that's kind of where I always look at, Eli, those letters. And, I oftentimes will have reporters get those letters from right to know request to public agencies. And the public agency may resist giving you that subpoena in the first instance. And I know we're going to have a whole hour on right to know, but certainly that's an area you should press, because ordinarily a subpoena to a public agency should be accessible from a right to know request.
So we've talked about a few sort of ways that are completely legitimate to get information on, whoever's giving you the information, the court or the witness, there's no bar on them giving you the information. There are situations where there are leaks, and leaking grand jury information when you're bound, whether it's federal or state, bound by grand jury secrecy requirements is a crime. So we had the situation a few years ago where it was Kathleen Kane was ultimately convicted for directing the leak of grand jury material ultimately to a reporter of the Philadelphia Inquirer. Okay, so that no question that was a crime, and what she did was a crime, and it was found to be a crime in the courts, and she was ultimately convicted for it. That information was published by the newspaper, and then so the question then becomes, okay, you've got your witnesses who you know can talk, you've got your attorneys you know can talk. What if you have a situation where you know there's somebody who's bound by grand jury secrecy? Can you go ahead and ask them to nonetheless provide you information? And I think that's sort of a gray area, and one which is risky for any journalist in that situation. I think there's a strong argument that there's a First Amendment right to ask people questions and to do your job as a reporter. I know there's people who feel strongly on the other side that actually is trying to strong arm someone to violate grand jury secrecy is in and of itself a crime. So that's an area where trepidation is certainly appropriate. But there are also situations in which, you as a reporter, you may end up with information that is grand jury protected, but you didn't do anything active to get it in the first place. Or perhaps you didn't know that it was grand jury material, or you didn't know that the person was bound by grand jury secrecy. In that situation, I would say it's much clearer. There's a US Supreme Court precedent that says that unless you violate the law yourself, publishing information about a matter of public concern is absolutely protected. So there's a US Supreme Court case called the Bartnicki case, where somebody illegally intercepted material in violation of the Wiretap Act, right? Used a radar to intercept a phone call, and then put that in the mail, and it showed up at a reporter's desk. The reporter then published it, and the US Supreme Court said that reporter didn't do anything wrong. They just ended up with this material. That's fine. I think the situation where it shows up on your desk is pretty clear. The closer you get to being involved in procuring the information in the first place, knowing that it's protected by grand jury secrecy, that's where you get into more danger, both sort of as an ethical matter and as a legal matter as well. And I'm sure that's sort of what your intuition would likely be anyway. So we've talked about sort of different ways to get information. Then say you end up as a witness in a grand jury situation. And there, a good example would be, say, you are the reporter, or your newspaper publishes grand jury information, and the government wants to find out how you got it in the first place. And really how this plays out, ultimately, and assume you got the information from a confidential source. How this plays out actually turns on whether you're being looked at by a federal grand jury or a state grand jury. And that surprises a lot of people. And I think it sort of defies common sense, but state law and federal law work differently. So we have the Kathleen Kane investigation, where an Inquirer reporter got, what ultimately was determined to be grand jury information. He was asked to testify before the grand jury, and refused to reveal the identity of his confidential source. And that's because the Pennsylvania Shield Law, which is absolute and has been interpreted as absolute by the Pennsylvania Supreme Court, says as a reporter, you don't have to give up any information that could lead to the discovery of the identity of your confidential source. That doesn't mean you can say, I'm not going to say anything at all about what the source told me. I'm not going to, talk to you at all. But it means you can say, I'm not going to give you any information. I'm not going to give you the name. And I'm not going to tell you, who it wasn't, so you can narrow things down and figure out ultimately who it was. And I'm not going to tell you other information that could help you figure out who it was. And here, that assertion of privilege was sustained. There was a request for testimony. Then there was a request for original copies of the leaked documents. And we posed that, saying that you could check that for fingerprints and, then go ahead and try to figure out who the person was anyway. And that was sustained. And I don't think it was a reach to sustain the objection, because the law is quite clear in Pennsylvania. On the flip side, you have the federal system. If you are in a grand jury investigation of a federal crime, the Pennsylvania Shield Law, there's a very strong argument that it does not apply. So you're left with whether there's a federal privilege. And the US Supreme Court hasn't really cleared that up. There's decent law in the Third Circuit, where we are, to suggest that there is a privilege. but it's not fully established. It's a little bit, there's some ways to potentially pierce it depending on how important the information is to the government. And in other circuits, there's no privilege at all. So there we had a parallel situation to the Kane case where there was Judith Miller, New York Times reporter, right, who supposedly, knew who had leaked information identifying a CIA agent. This is the Valerie Plame, James Wilson situation a few years ago. There was a grand jury investigation into that leak because it was classified information. It wasn't grand jury information, but it was classified information about the identity of a CIA operative that wasn't allowed to be shared. She refused to testify, asserted that there was a privilege under the First Amendment not to out her source. And the court said, no, that privilege hasn't been recognized. You have to testify or go to jail. And she ultimately went to jail for 2.5 months until her source really came out and said, hey, you don't need to do this anymore. I'm okay with you testifying. And I'm sure, when you talk to people and you deal with confidential sources, you're not thinking ahead to say, could this possibly lead to a federal grand jury investigation or a state grand jury investigation? But ultimately, it actually makes a really big difference. And so, fortunately, the Kane investigation played out on the state side as opposed to the federal side. I imagine a reporter would have, then gone to jail to protect his source if he had to on the federal side, but fortunately didn't have to do that. So that those are, really the key differences. But I think it's important, and I think you would think this anyway, if you find yourself receiving a subpoena or being asked to testify before a grand jury, know that you have the right to assert your privileges. It's not just the attorney-client privilege. It's not just the privilege against self-incrimination. It's the privilege to protect your sources and potentially to protect your other news gathering materials, where it's important to get a lawyer involved, but it's important not to just start talking because there are avenues to assert those privileges, as Jennifer said, and as Mike said, and protections that are built into the process for you. So I think we're just about out of time. I don't know if Mike or Jennifer had anything final to add in.
Well, I can tell you this. Oh, sorry, Jennifer, go ahead.
I just wanted to add that unlike the federal system, we do not have a docket that's available in connection with our statewide investigating grand juries. The filings for our grand juries are filed with the county clerk of courts in the county in which the grand jury sits. However, the docket and the documents being filed are all under seal, so that information is not publicly available.
Well, this was very interesting to me as a former civil litigator who knew nothing other than what I read in the newspapers. So this was very helpful. So thank you all very much. And we will now move on to the next panel, which actually talks about the Right to Know Act and how you can get information that should be publicly available to you. So I'm going to hand this over to Michael Joyce, Nathan Byerly, and Melissa Milewski. Thank you very much.
Hi, folks. My name's Melissa Milewski, and I'm going to talk today with Michael and Nathan about the Right to Know law. And I'm just going to start sharing my screen so you all can see. We have a PowerPoint that I think will help us kind of stay on track and hopefully give you a little bit of guidance if you end up needing it in the future. Let me just share my screen. So there you can see all of our contact information. And what we're going to talk about today is really just getting to know the process of the Right to Know law. I'm going to talk about the request stage. Nathan from the Office of Open Records is going to talk about the administrative appeals and mediation process, which is the intermediary level. And then Michael from Saul Ewing in Pittsburgh is going to talk about judicial appeals and penalties and the processes involved there. If you have questions, please put them in the chat. After I'm done talking, I will be monitoring those. So if you have questions, please just let us know. So I'm going to talk about the basics and tips for requesters. And my name's, as I said, Melissa Milewski. I'm in-house counsel with the Pennsylvania News Media Association, and I've been doing this job for, it's 15 years this month. So I was around before the current Right to Know law was in effect, and I was there when it was passed, and I've been dealing with it ever since it came into effect in 2009. And I talked to Public access questions, I get on the hotline, we get around 2,000 calls a year. Half, if not more than those, I deal about 1,000 a year deal with right to know law and public access issues. So this is something I talk about every day. And I'm happy to give you some tips on how to navigate the initial stages of the right to know law. So I'm going to touch on some of the significant provisions of the right to know law. We don't have time to get into all of these in detail. We would need an entire day to do that. We are limited with time, but the significant provisions of the right to know law, which is linked there in the process or in the PowerPoint, is the presumption of access and the burden of proof for denial. The presumption is records in the possession of a government agency are public unless and until an agency can prove by a preponderance of the evidence that they are not accessible to you. And that burden of proof lies with the government agency. And that makes sense when you think about it, because typically the party with the burden of proof has all the information. And in this context, the government agencies have all the information about the records in their possession, and you, the requester, do not. So it makes sense that the burden of proof applies to the agency. So the definition of record and public record are expansive. If an agency has a record, whether it's electronic, whether it's paper, maps, blueprints, metadata, that's going to be records of an agency typically. Now there's a lot of cases on what of an agency might mean and kind of nuances in the law, but the general presumption is if an agency has it, relates to its business, it's going to be a record for purpose, it's going to be presumptively public record for purposes of the right to know law. The right to know law, the current right to know law also covers the General Assembly and the court system. They cover them differently than the administrative level agencies. So with regard to the General Assembly, there are 19 categories of legislative record that you can get under the right to know law. The courts are covered by the right to know law. Their financial records are considered judicial records accessible under the law, although the court system itself doesn't use the right to know law. They have implemented what's known as the Rule of Judicial Administration number 509, which is similar to, but not the same as the right to know law. So if you want to make a right to know law request of the courts, it's going to be made under Rule 509. And there are forms on the AOPC, the Administrative Office of Pennsylvania Courts has their public records request forms related to Rule 509 on their website, and they're easily accessible and usable. Now, what you do want to remember, and it's really important to remember this distinction, right to know law Rule 509 records only deal with the financial aspects of the court system. How much people are being paid, who's being paid, what are they paying for, how are they spending the money of the court system. That's what's covered by the right to know law and Rule 509. If you want to access a court record, a judicial record from a First Amendment perspective, so something that's filed with the court in a case, something that's relied on by a court in a case or controversy, those are judicial records in a constitutional and common law access, and they are accessible under those laws. They are not accessible under the right to know law or Rule 509. So always bear in mind that distinction. Am I looking for a record that's filed with the court, or am I looking for a financial record? If you're wanting a financial record, how the court's spending or making money, that's Rule 509/right to know. If you want something that's filed in a court, you'll go to the public access policy that applies across the state. The other significant provision of the right to know law is the Office of Open Records, which was not around 12 years ago. The Office of Open Records is the place where most administrative level appeals are filed. There are some exceptions to that general rule, but most of your administrative level appeals will be filed with the Office of Open Records. And Nathan's going to talk to you a little bit more about that process today. Email requests are expressly permitted under the right to know law, and I recommend them for a number of reasons, but requests can be submitted, in person, via mail, via a portal if an agency has one, via fax. But email is really the preferred method because it allows a timestamp, and calculation of time can become an issue. So emails are the preferred method. Response time. Once you get your request put together, the agency and submitted, the agency has 5 business days in which to respond to you initially. Within that 5 business days, they have to grant access and provide access to the records, deny access and explain why, and provide an appeal mechanism, or at least explain how you would file an appeal. Or they can take an additional 30 calendar days in a number of circumstances. And I'll talk a little bit more about that in a moment. Things you also want to bear in mind as we go through the significant provisions is that the law reaches contractor records, contractors who are performing a governmental function, and records that are directly related to that function are covered under the right to know law and accessible, which is really necessary because government continues to outsource its duties and responsibilities under statute to private third-party contractors. Those records are reachable under the right to know law. The state-related institutions are covered, but very limitedly. So the state-related institutions are Penn State, Pitt, Temple, and Lincoln universities. They are covered, but they only have to provide certain information about their top 25 paid salaries, their board member salaries, and their annual 990 information. And that's an annual disclosure that you can get from them. The right to know law also created an online searchable database for state contracts valued over $5,000. It is a wealth of information. If you have not visited the Treasury Department's Library of Contracts, check it out. There's a whole lot of stuff there you can dig through. Also note PennWatch. PennWatch is a separate law created under a separate act of the General Assembly, but that's your salary and budget information for all the state level agencies. Again, these are the Treasury Department website and PennWatch are sites that proactively provide information. There's no need to go through a right to know law request if you can get what you need. That's what's already posted right there online for you. Exemptions in the right to know law, and these are significant provisions of the law. There are 30 exemptions for various categories of records under the right to know law. So an exemption is, if an agency can prove an exemption applies, it means the presumptively public record can be withheld, can be denied access. And there are various categories for safety, security, investigations, deliberative records. There's a whole bunch of them. We would need an entire day to go through the details about all of them. But the thing I want you to remember most about the 30 exemptions is that none of them are mandatory. There's nothing in the right to know law that says an agency must assert an exemption, even if it applies. An agency can always give you an exempt record if it serves the public interest. So can you guys hear me?
Yeah, now we can. You had,
Okay.
You were muted for a second.
Okay, thanks. If you know you want an exempt record, don't be afraid to ask for it. The worst that happens is they say no. An agency can always give you an exempt record when it serves the public interest. So if you know you want something that's specifically exempt, like an investigatory record, make a public interest argument right there as part of your request. Like I said, the worst thing that happens is you get a denial. You don't lose anything except the 4 or 5 minutes it takes to put the request together. I also want you to bear in mind financial records and aggregated data. Most of those 30 exemptions do not apply to financial records or aggregated data. Now, financial records are obviously records that deal with the receipt or disbursement of public funds. And if you're dealing with a financial record, there are several exemptions that apply that allow redaction of those records, but it never allows the wholesale denial of a financial record. At a minimum, you should be getting the financial aspects of the record. Aggregated data is data that's been de-identified. The thing that I've been talking to journalists in the past year about is aggregated data from the Department of Health about vaccination rates, infection rates, things like that. That's aggregated data. You can't tell who is involved in it, the specifics. You can't determine who the people involved are, but you get a sense of what's going on. It's de-identified, but it still paints a broad picture. Most of the exemptions in the right to know law do not apply to aggregated data. So just bear that in mind. I also want you to bear in mind the right to know law's relation to other laws. If there is another law that makes a record public or non-public, the right to know law is superseded by those laws. So just be aware. And there are literally hundreds of other laws and regulations that either make a record expressly public or make it non-public. So if you're dealing with one of those situations where you know there's another law that's applicable, you may have to file a right to know law request, but as part of that request, you'd want to talk about the fact that there is a specific record or there is a specific law that makes this public. So for example, this comes up a lot in the past year in the context of the election code. There are various provisions in the election code that make certain records related to the elections and voter registration records expressly public. because there are those specific provisions of the election code that make records specifically public, the right to know law and its various exemptions don't apply, even if they conflict with the right to know law. So just bear in mind, and the same goes with judicial records and from a First Amendment and common law perspective. If a record is public from the court system because it's constitutionally required to be public, the right to know law and its 30 exemptions don't apply. So just bear that in mind as you're moving forward. So what are your initial steps? You know you need some information, and you know an agency might have it. The first thing you want to do is think about what kind of agency you're dealing with and what are the records. Are you dealing with a local or Commonwealth agency? So for example, are you dealing with a school district, a county, the Department of Health? Are you dealing with one of the local or Commonwealth agencies that are administrative? They fall under the governor or the executive branch of their government. All of their records are presumptively public under the right to know law. If you're dealing with a legislative agency, the state house, the state senate, the legislative budget finance committee, there's a kind of smattering of legislative agencies under the right to know law. If you're dealing with a legislative agency and a legislative record, be aware that the right to know law doesn't cover all of their records. It's not the same as getting an administrative level, executive level agency record. The right to know law covers legislative records, and there are 19 specific categories that talk about or that define what a legislative record is. And again, we've already talked about judicial records and financial aspects. The next thing you want to think about is, are the records covered by the right to know law or a different law? And we've already kind of touched on that a little bit as well. If you're dealing with a different law and that law sets out a separate request process, you must follow the separate law. The next thing is, do you even need to do a right to know law request? Is a request necessary? This is the first thing I tell journalists when we chat is, have you just asked them for the record? Sometimes it's just easier to send an email or to pick up the phone and say, hey, look, this is what I'm looking for. The right to know law is not a required process. A lot of journalists think, and agency officials for that matter, think the right to know law is the only way you can go about getting access to public records in Pennsylvania. It is not. And as working journalists, you will have relationships with people at these agencies. Call them up, go through the press office. Once you get involved in the right to know law process, it typically is going to involve lawyers who like asserting bases for denial. That's not always necessary or appropriate. So the first thing to do is exhaust informal means of access before you start the right to know law process. You may get records that aren't necessarily public under the right to know law as part of an informal process. You may get access quicker under an informal process than under the right to know law process. So think about that and exhaust informal remedies before you start filing right to knows. If the right to know law is necessary, you need to figure out who the right to know law contact person is at the agency. And sometimes that can be difficult to determine, especially when you're dealing with an agency who has high turnover in that role. And that happens more often at the local level than the state level. But you need to, if you don't send your right to know law request to the appropriate person, it can be ignored. So just be aware that you need to really figure out who you're dealing with. Next step. So you know who you're talking to, you know who you want to send your request to, you know what you're looking for. What do you do next? Use the Office of Open Records uniform request form. It has to be accepted by every agency in the Commonwealth. Some agencies have their own form as well, but everyone's got to accept the OOR's form. Use it. It sets everything out. It makes it simple. And this next issue that I'm going to talk about is one of the most common reasons that you will be denied access. You're not specific. So the right to know law requires requests to be sufficiently specific so that the agency can figure out what you're looking for. It doesn't require to use magic words or key terms, or if an agency uses a specific terminology to address it, you don't have to use those magic words. You do have to be specific enough so that they can figure out what you're looking for and can figure out if they have it. When dealing with specificity, the courts have created a three-part test. And my recommendation to requesters and journalists is go through this three-part test before you submit a request. If you're missing one of the three aspects of this test, it's something you should think about beefing up your request to address these issues, because agencies, although these are not required, these are not statutory requirements, these are court created, agencies will look at this test And if you're missing one of the aspects, they'll deny you for specificity, even if what you're looking for is kind of plain and simple to understand. So go through the specificity test and make sure that your request complies with it. And I'll hit on the big kind of 3 aspects of it quickly. Subject matter. Your subject matter has to identify a transaction or activity of the agency. Now, keywords alone are generally not sufficient, but they can be helpful. So keywords come up a lot in the context of requesters who are looking for emails or text messages or other electronic records. Keywords can be great, but they don't, by themselves, they don't tell the agency what the subject matter of the request is, and they don't identify the transaction or activity of the agency. So you really need to have the subject matter, which is the transaction or the activity of the agency, and you can provide some keywords to help them figure out exactly what you're looking for. Don't give them keywords alone. If you only have keywords, that's an invitation for a specificity denial. Don't do it. The second thing on the test is the scope of the request has to identify a discrete group of documents, either by type or by recipient. So you've got to kind of narrow down the world of records in which you're looking for. Don't say things like any and all, including but not limited to. Those are invitations for denial for specificity. Don't do that. You've got to give them a discrete group of documents. So if you know certain public employees were involved in an email chain, give them the employee names. If you know their job titles but not their names, give them the job titles. Include that information. Anything you know that can kind of beef up the specificity or the details about what you're looking for. If you know an agency uses a specific term to refer to a record, use that term. If you don't know the term, and that's often the case, you don't know the term, describe what the record contains or what it's used to document. The more information you can give them, the better off you'll be from a specificity standpoint. And the final and most flexible aspect of the test is a time frame. You've got to identify a finite period of time for which records are being sought. So give them a date range, May 1st to July 31st. I'm sorry. Yeah, May 1st to July 31st. That could work. 7 years, that could work. Just because a time frame is long doesn't necessarily mean it's not specific, although you're likely to get pushback from the agency if you request 45 years worth of documents. So, be aware that that's an issue. You should have a time frame. If you don't include a time frame, if the other two parts of the test are very specific and very limited, you may not need a time frame. And there have been cases that have held as much. So just be aware that these aspects are flexible, but to the extent you can include them, you should. You are not required to explain to an agency why you want a record. That is specifically set out in statute. You don't have to do that, and an agency cannot deny you for refusing to tell them why you want a record. With that being said, if that's something you can share, that's something to consider. It may help them narrow down what you're looking for, especially if you're not sure what you're looking for. And other drafting tips I'll talk about quickly before we head over to Nathan. Request electronic copies when possible. It cuts down on fees. Generally, there's no fees for electronic copies unless they have to print out for redaction purposes. You have to include the name and address and email to which an agency should respond. So just be aware that they need to know where to reach you. Make it easy for them to reach you, because this should be a communicative, collaborative process. It shouldn't be adversarial, although oftentimes it is. It shouldn't be. Again, be sufficiently specific, and see the points above we just talked about. Avoid fishing expeditions. If you don't know what you're looking for, you're not ready to file a right to know law request yet. Don't go on fishing expeditions. There's case law that says that's a bad idea. If it's a big request, if you know you need 10 years worth of documents and there's going to be about 50,000 emails, be reasonable. Ask for a rolling response where records are provided over a period of time. And you can be as flexible with the timeframes as you want. That's one of the great things about the right to know law. You, the requester, you can give the agency as much time as you think they need and deserve to answer this request. So just be aware that, agencies are doing multiple things. during the day. They're not just dealing with right to know law requests. They are required to respond within a certain time frame. If you know what you're asking for is detailed and voluminous, be reasonable and be flexible. The journalists I talk to who make those kinds of large requests oftentimes include right in their request, they say, you know, I'm willing to work on a rolling response. I'm flexible with timeframes. Here's what I'm looking for. And that generally works. You catch more flies with honey, as my grandmother used to say. So just be aware that, you know, sometimes timing is really, sometimes you don't have the flexibility as a journalist to be flexible with times. Many times you will, especially if you're dealing with an in-depth investigation that's going to last several months. And again, you're not required to give the reason for your request, and they can't deny you for doing so. But sometimes it helps to explain what you're looking for. So don't be afraid to pick up the phone or send an email and just reach out to the agency and say, look, this is what I'm dealing with. And that should work both ways. The agency should say to you, I don't know what you're looking for. They shouldn't just issue a denial. They say, hey, I don't understand what you're looking for. And you can say that right in your request. If you have any questions about this, please contact me. I will explain it more. Final steps before you submit. Again, confirm the right to know law person's contact information, and the OOR has a database of contact info. The agency can confirm that as well, and it's supposed to be posted on their website if they have one. Use email submission if possible, because it helps establish receipt time, and for date calculation purposes, it makes it easier to determine when the deadlines actually apply. Also, ensure that you don't owe any unpaid fees for prior requests, and not just you, but your newsroom, because when you're a journalist, you're making it in your own name, but the requester is really your employing news organization. If your news organization or a particular reporter, if you owe an agency money related to prior requests, they can deny you if you have unpaid fees, even if it's just 10 cents. So just be aware, make sure you don't owe them any money. Keep the timeframes in mind. Once you submit your request, it's 5 business days, calendar week, for an initial response, and that initial response has to be done in writing. And they can, in certain situations, they can take 30 calendar days extension in limited circumstances. But unfortunately, this has become routine with many agencies, especially during COVID. So keep those things in mind. And the last thing I'm going to talk about today is fees. Always, as a journalist, always ask for a fee waiver in the public interest. What you're doing as a journalist serves the public interest. Agencies can, and in many cases should, waive fees. It doesn't hurt anything to ask. You're not losing anything by asking for the waiver. Some agencies will grant it. They won't grant it if you don't ask. The OOR sets the fee schedule, and you can see that linked on their website there in the PowerPoint. Just be aware that the basic fee is 25 cents per page for black and white copies. No fees for electronic copies unless they have to print something out and physically redact it and then scan it back in. No fees are permitted for staff time or legal review. And just, I want to note this because it's a provision of the law that deals specifically with journalists. Complex data set fees can be market-based if they're approved by the Office of Open Records, but those market-based fees for complex data sets cannot be assessed against members of the media. And that's set out in section 1304D. So you see this most frequently with, like, a complex data set might be something like the property tax assessment GIS database. Agencies can and do charge thousands of dollars as a commercial-based fee for that. They cannot charge you, a member of the media, that market-based fee. They can only do 25 cents per page, or if it's on a CD, it's like $3, I think. So just be aware there's a wrinkle there. If you're looking for a complex data set and they try to charge you a market-based fee, it can't be assessed against you. The legislative Senate House is 25 cents per page. Judicial agency fees, Rule 509 allows reasonable costs. For anything, 10 pages and under, it's free. 11 pages and up, it's 15 cents per page, $5 for a CD. Postage equals the actual cost. So at this point, I'm going to turn it over to Nathan, because after you've done all that work on your request and you filed it, sometimes you get a denial. What happens if you get a denial? And for that, I'm going to turn it over to Nathan Byerly, who's a Deputy Executive Director of the Pennsylvania Office of Open Records.
Thank you, Melissa. I just wanted to say thank you real quick for the invite on behalf of our Executive Director, Liz Wagenseller. And this is a great program, a great opportunity for people to learn how to use the tools that they have to be able to access government records. And before I jump in, I want to start with emphasizing tools that you can use, and I want to end with tools that you can use. So if there's one thing you take away from this presentation, or my presentation, is where to go to get the help you need to walk through this process beginning to end. And the Office of Open Records has a webpage that we maintain on a constant basis, and you can go there. There are guides there, there are videos there, there are forms there that will walk you through the entire process, start to finish, with the right to know law. So keep that in mind as you hear, the presentations today. It's going to be a wealth of information. There is a place you can go after this that will walk you through it in a very simplistic ABC 1, 2, 3 type of method. We at the Office of Open Records, we're an independent quasi-judicial agency, and we hear the appeals from denied right to know requests by local and Commonwealth agencies. So if you go to an agency and you say, hey, can I see a budget, and they tell you no, you can come and appeal to our office and we will hear that appeal. Now, advancing the slides, guys, do I do that?
I'll handle it, Nathan.
Okay, thank you. So there's a number of different ways you can submit an appeal. So again, looking at the tools that are available, I'm going to start there. We'll get into some of the details in a little bit of what the timeframes are with the appeal. But you can go to our website, and we have a form set up there. You can submit it online. It will give you help in walking through what information we need to process the appeal. It will tell you like your name, just the basic information. And on the next slide, you will see that there's also a walkthrough of requirements that you need to give us. Give us the date of the request you made, give us the date of the agency's response. And additionally, the next slide will show and walk you through questions you need to answer that will get you through the door, and what documents you will need to continue the appeal. So you're supposed to give us a copy of the request, a copy of the agency's response, any extension that the agency may have given. There are certain requirements. You're supposed to address what grounds the agency denied that request on, and to say why you think the record should be public. We walk you through all of that. Check boxes can meet the standard as well. So I emphasize what Melissa said, like the right to know request form that's uniform and you can use to make a request. Use this appeal form to walk through the appeal at the Office of Open Records as well. We also have this in hard copy format so that you can print it, fill it out, scan it, send it in via email, fill it out, and submit it via email. And if you're still, and friends with your fax machine, you can send it via fax as well. Once we at the Office of Open Records get the appeal, you will get from our office a notice of appeal, and that notice of appeal will break down some very key issues, and that will tell you who your appeals officer is, what the deadlines are, and the mediation is an opportunity. But even before you get to that stage, your first question is probably going to be, well, what's my time frames here after I file the right to know request? So you file the right to know request, the agency tells you no, or they don't even reply. And if they don't reply, within the 5 business days, it's automatically denied, and you can appeal after that time. You have 15 business days from the date of denial. And I will give a little warning here because we do see this come up, and I don't want to say it comes up more with journalists and media because they're juggling so many different stories at times, but we see it come up consistently with them. If you go to the agency and file the right to know request, and they wait until the 6th business day to send you a 30-day extension, even though they sent you the extension on that 6th business day, since they didn't respond, it's automatically denied. So from that point on, that's when your 15 business days or 3 weeks begins to run. So what we see people doing is they'll get that 30-day extension on the 6th day and think, oh, I'm good, I'm going to wait. They wait the 30 days, they come to the Office of Open Records. If they don't hear a response or they disagree with the denial that the agency gives, they file the appeal with us, but the time has already run. The 15 business days are expired, and that appeal is untimely, and the requester will have to go back and start the whole process again, which brings up something I'd like to point out. It was mentioned at the beginning in the opening statements, is as you come into this process and as you go into the process in other states and even federally, know the rules, know the system, know the lingo, learn it, know where to go to get that information. Use these tools. And I think about it doesn't matter if you're Michael Jordan, LeBron James, or a middle schooler. You walk onto a basketball court, you gotta dribble. That's the rule. And if you don't dribble, you're gonna get called for traveling. Just like in these systems, if you don't do something you're supposed to do, you're gonna be untimely, you could be dismissed, you could get your case denied. One of the big things that Melissa was mentioning as well was specificity. And I noted it in the chat, and I'll say it here again. The appeals officers asked me specifically, work on specificity. Reporters and journalists, especially for some reason, struggle with this. And I think it's probably trying to cast a broad net to get as much information as you can, but limit and really narrow in on what records and what information you're trying to get. That would be much more helpful on appeal. So jumping back into the appeal process, you've gotten the notice of appeal from the Office of Open Records. It has broken down for you who your appeals officer is, what your deadlines are, and the possibility for mediation. Now, I want to point out, we only have jurisdiction over local and Commonwealth agencies. So we do get appeals come into us from that apply to the Auditor General, the Attorney General, State Treasurer, Legislature, and Judicial, but we don't have jurisdiction over them. So we will transfer them to the appropriate jurisdiction, but file them with that agency, because they have their own appeals officers, they have their own appeal process. They're bound by all the same procedural standards that we are under the right to know law, but they are their own jurisdiction. So make sure you do not confuse the two, because again, that can cost you time. And if you make a mistake with filing something somewhere, it could get your case potentially dismissed. And then again, like I said, you have to start the process all over. And knowing the timeframes that a lot of these cases are involving the media, time is of the essence. So moving on, you now have filed that appeal with the Office of Open Records. As I indicated on this slide, there are certain things that you need to address and you need to include. Our appeal form will walk you through the process. Like I said, there's YouTube videos on our website that will walk you through the process. But once you get that appeal, and once you have filed your appeal, the Office of Open Records has 30 calendar days to issue a decision. And that is not a lot of time, and especially not a lot of time in the legal world. We give the agencies a short amount of time to respond to the appeal and to give us the evidence and to give us the legal argument that they're going to. As Melissa pointed out, the burden is on them to show why this record or why this information should not be released. It is not on the requester. So the requester is technically not required to file anything in legal argument. Many times, and most of the times they do, but it's not necessarily required. The agency, if they do not file anything, will automatically lose the appeal, and we will grant the appeal. But once they submit legal evidence to us, which we do not typically conduct in-person live hearings, it's typically documents that we look at. We look at affidavits, sworn statements, and they'll combine that with a legal argument that they submit to the office. The appeals officer will look over that, look at the argument that may be submitted or any evidence that the requester may submit as well, and reach a decision and issue a final determination within 30 days. Now, the requester can extend the time beyond the 30 days, and there will be times that appeals officers will reach out to the requester to ask additional time. And there are a few exceptions to that 30-day statutory standard that we're bound to. It was severely impacted recently and can be impacted by worldwide pandemics. Who thought we would ever have that type of situation? But there we were, facing that like everyone else. The courts have not addressed some of the time issues in the final determinations where we took longer than 30 days or took extensions or extended things, but they have not said that those were inappropriate as well. No parties or anything have challenged it either. So we are very flexible in dealing with pandemic type situations where the system is dramatically impacted. So in looking through the evidence, the appeals officer will collect that from the parties, take a look at it, make a decision as to whether or not the records should be released. One thing I would point out is if you are a requester and the agency submits an affidavit and you look at the affidavit and you're like, wow, this is so way off, or this is just false. Don't wait till after the final determination is issued to go back to the appeals officer and say, you know, hey, this was wrong. Raise it then, and ask the appeals officer for time to respond to the affidavit. You may need to give additional time to the appeals officer to process that, and it may take longer than the 30 statutory days. So, be flexible with giving them that extension to consider any evidence or any statements that you want to make in opposition to an affidavit you think is false or even could potentially be involving a situation of perjury, which is very rare that we see that. We see more a disagreement with statements that are made within the affidavit factually that the requesters want to expound upon and point out to the appeals officer. But it is better to request to the appeals officer before they issue the final determination than to wait till after the determination. We also, at the Office of Open, and then once they issue the final determination, if you disagree with that or the agency disagrees with that, they have the ability to appeal that decision to the courts. A local agency would be appealed to the local Court of Common Pleas. A Commonwealth agency would be appealed to the Commonwealth Court, and you have the statutory and legal timeframes that govern your appeal rights there. And once it goes to the courts, it would become going through the judicial system, just like any other case would go through that. But before, we also, at the Office of Open Records, we also maintain a mediation practice as well. And you can request this up front. There's a box on the form that says, I would like to request mediation. Both parties have to agree and be involved. So the requester and the agency both have to agree that they're going to go through the mediation process. It's confidential. It's also something you can do. Let's say you get the submission from the agency and you look and see, oh, wow, they might be misunderstanding my request. Can we sit down and mediate this? And you can reach out to the appeals officer and even request mediation midway through the case to see if the parties can sit down, work this out. You can get the records that you need, and the agency can preserve the redactions or withhold the records that they think they need to withhold. Our mediators are trained. They go through a course that they take that walks them through and gives them experience. And the process can save time and expense. And I will say up front and admit, one of the concerns that has been expressed to me in the past with the mediation process is it can take a little bit longer than, and sometimes it can take much longer than the final determination process. But we have seen it really produce great results and save, in the end, time and money for requesters and for agencies as well. One of the other things I wanted to point out was that the mediators will transfer non-successful. I mean, if you're going through a mediation process and it's not successful, it would transfer back to the appeals officer. So an appeals officer will then hear the case and issue a decision. We are in the process right now of reassessing and looking at our mediation process to see if there are ways that we can work on the timing and make it be a more efficient and effective process that people go through and get, say, faster resolution than the mediations have in the past. And moving on to to the next slide, just a couple tips to follow up on here. And my screen just went crazy on me. All right, tips. Appeals officers. Like I said, during the process of the appeal, they may reach out to you and the appeals officer may say, hey, I'm running into some issues. I need some additional time. To the extent you can, and I would say give that to the appeals officers. They do not reach out for these requests for additional time lightly. They are either struggling from a caseload that is slowing them down on potentially your case, and they want to give more attention and get the right result in your case, or there's a wrinkle that all of us at the Office of Open Records are working through. It may be a novel issue that's come up. It may be a complex issue. But when they come to you for additional time, it is not just because they just want additional time to be able to go do whatever in their personal life. It is a legitimate professional legal need that we need that extra time. And Another thing that we see is requesters amending and trying to change up the request on appeal. You can't do that. We can only look at the request you filed with the agency. So if you adjust it a little bit to try to make it narrower or try to fix some of the terms, the way you define terms, it's best to just withdraw the appeal and file a new request and see if the agency will work with you on getting those records as well. And just giving a background of what we're facing right now, we have 20 people as our total staff. We are right now seeing just record numbers. It kind of leaves me speechless at times. We are really working to try to even keep up. We're on pace for record numbers and appeals for this fiscal year, and people are much more engaged in government because of things that are going on. I believe the pandemic has also brought many issues to the forefront that people want to know what their government is doing, why their government is doing it, how their government is doing it, and they're using the right to know law process to do it, which is great and wonderful, but it keeps us very, very busy. So as you get those requests from appeals officers, please keep that, for extensions, please keep that in mind as well. We also provide training. We don't have any jurisdiction over the Sunshine Act, but we are given training responsibilities. So we have become, for all intents and purposes, a hotline that people will call and ask questions regarding public meetings. They do the same with the right to know law. We have and handle thousands and thousands of emails and inquiries and phone calls to our office annually to try to get guidance on how to do different things. Now, we can't provide legal advice. We're not going to be an attorney for any party that may call in, but we can point you to a final determination. We can point you to a case law that's on point. We can point you to any number of resources that will help you get the answer to your question. We get a lot of misdirected requests. Where do I get my birth certificate? Where do we get death certificates? And we try to the extent that we can point those people to the right agency so that they can get the records and information that they're looking for. But that is basically it in a quick and fast nutshell. I also want to highlight this last one. The appeals that we handle are a small percentage of the actual requests. And now there was a study done by the legislature in 2018, and I think this was an estimate, and I think it's even low, and I would say even low now in 2021 and looking back at 2020. And one of the ways I pointed out is it's a very small percentage that we handle. So we get roughly 3,000 of those 109,000 requests as appeals. If we get just a fraction of an increase, small percentage increase in the requests, or a small percentage of requests getting appealed to our office, we're going to be inundated and completely buried. So just something to keep in mind as you talk to lawmakers and publish your stories too, to keep an Office of Open Records that's well-funded and well-staffed is very important to the entire process. And with that, I will turn it over to Mike. Oh, real quick too, I said I would end and begin with tools. This is a great resource that we give you. I would highlight the one, you can sign up for email lists that we will send you a daily digest of the final determinations that we issue. We give general updates. We have an email too that will update you on all the court filings that are going on in right to know appeals that have been filed in the courts. It's, Twitter, follow us on Twitter. We have the YouTube channel that you can watch some of the training videos that we post on there. We are offering constant webinars right now. We have with the Sunshine Act and the new change to agendas. We're running webinars on those on a consistent and weekly basis. So if you need any information related to open government, open meetings, open records, please feel free to reach out to us through email, give us a call, and we will, to the best of our ability, point you in the right direction. We have a standard within our office, and we've stood by it for the most part, is to try to get back to the callers within 24 hours, 24 business hours, and try to point you, like I said, in the right direction. So with that, I will now turn it over to Mike.
Thanks, Nathan. Good morning, everybody. My name is Michael Joyce. I'm a partner at Saul Ewing in Pittsburgh. I'm a litigator. I primarily handle commercial disputes, but I do have a good media practice, and I've had the opportunity to represent media companies and other clients in right to know cases specifically. I had one recently go to the Pennsylvania Supreme Court, and I'll try to talk about that a little bit at the end. And I currently have one for a professional sports team involving a right to know request. Today, I'll focus on the judicial process with the right to know law. So at this point, we're past that initial request stage, which is what you heard about from Melissa. And we're also through the OOR process, which we just heard about from Nathan. And if you're a requestor or otherwise an agency that's dissatisfied with the result at that point, either party can seek the assistance of the courts. And there's sort of two flavors or two types of judicial intervention in right to know law litigation. The first is an appeal. And this is when either side wants to challenge the ruling of the OOR. So that means the requester was denied access, but still thinks he or she's entitled to information. Or on the flip side, if the agency is told to produce records and thinks it should not have to, it can also appeal. There's also times where maybe the OOR rules partly against either side, so you might have cross appeals. Luckily, I think appeals relative to the number of requests that the OOR handles are relatively rare, but you still see a decent number of cases filed in the courts. I think the most important thing for an appeal is just to remember that you have 30 days to appeal from the final determination, and if you fail to appeal within those 30 days, you generally lose your right to do so. The second course where a court might get involved in right to know law litigation is called an enforcement action. This arises when the requester obtains a final determination from the OOR, but then for some reason or another, the agency just doesn't comply. That lack of compliance might mean that the agency produces nothing, or maybe just produces part of what the requester thinks it deserves. So this action is the requester asking a court to really force or compel the agency to comply with that final determination and to produce all responsive records. Enforcement actions, I think, are even more rare than appeals. I think there's only been really a handful under the law that have been published. And importantly, whereas you have that 30-day deadline for an appeal, you don't have the 30-day deadline for an enforcement action, because in reality, the ability to enforce a final determination doesn't arise until 30 days. That 30-day time period is when the final determination becomes final, and that's when an enforcement action will be ripe in the first instance. You've heard a little bit about today, but I think even if you're in a position to file an enforcement action, opening up a dialogue with the agency makes an incredible amount of sense. Courts want to see it. They want to see the parties playing nice and trying to work it out. Those conversations might also help you start to build a case for bad faith if that exists. You also might get some additional information or free intelligence out of that back and forth. And you never know, you might get the information and avoid any further action, which is always great. It could be a misunderstanding or just a dialogue would open it up. When you end up in court, there's two potential venues. The Court of Common Pleas is for local agencies, and the Commonwealth Court is for state agency related appeals or enforcement actions. And I think the procedure will generally be the same between them, but you'll certainly see nuances between the courts. You'll probably even see nuances if you have cases in different courts of common pleas, and likely even between judges. Some counties, including Allegheny County, actually have a special judge that handles the statutory appeals under the right to know law or some other statutes. I'll give a quick crash course in the judicial review process and just the general steps of how the case moves through the courts. The timing depends on the nature of the case. Ultimately, if you have a streamlined appeal, you don't have discovery, it's a pretty discrete issue. You could be looking maybe at 6 to 12 months to get through the process. But it could be much longer if you have discovery, if you have disputes in the middle, things like that. You could easily be looking at a year or two of litigation to sort everything out. You start by filing a petition. It can be relatively basic. It talks about the request, the agency response, what happened at OOR, and anything else that happened in between. If it's an appeal, you'd be explaining, why there's a disagreement with the OOR's decision. And if it's an enforcement action, you would just be describing what else is needed from the agency. Plus, if the party is seeking sanctions, that should be mentioned as well. That initial filing, that petition is really just telling the court what happened and what you want. The record on appeal, in the first instance, it normally starts with just whatever was available to the OOR. That's the universe of information that will also be available to the court. So you'd have the request, the response, any briefs or affidavits that were submitted to the OOR. If there was a hearing, the transcript would be there, and ultimately the final determination. That would all be provided to the court at the beginning of the case. The case law leans towards that record being that would be all the facts, all the information that are before the court, and then the parties make arguments based on that record. I think the idea is that these right to know law cases, even before the judiciary, aren't supposed to be unwieldy. They're supposed to be pretty discreet, but the court does have discretion to open up discovery, allow the parties to do some fact finding between themselves, asking written requests, asking for documents, deposing witnesses, things like that. I think discovery is particularly well suited for enforcement actions, because you often need the chance to really explore and confirm whether or not the agency had complied with the final determination. As to the standard of review, courts do not have to show deference to the decision of the OOR. The court can make its own decision. In practice, I think you might see certain judges, or maybe many judges, still showing a hesitancy to overrule the OOR because the OOR is the expert. And often has looked at the issues and decided the issues in the first instance, but that's certainly not irrebuttable, and that the judge is still going to look at everything and make a decision. And that decision is generally going to be written. You'll have some briefing, an argument beforehand, and a written opinion at the end of the day, but that might not be the end of the process. You could still have more appeals. Ultimately, if a party is dissatisfied at the Court of Common Pleas, you go to Commonwealth Court. And then after the Commonwealth Court, whether you're there originally because you have a state agency issue or you're there on appeal from the Court of Common Pleas, either party can ultimately petition to the Pennsylvania Supreme Court. The goal of most right to know law litigation is to get the information, right? That is the basic reason for the request, and that's generally why appeals or enforcement actions are pursued. There is the opportunity, though, for sanctions. The Right to Know Act, which was the predecessor to the law, actually had criminal penalties, but those were eliminated when the Right to Know law was created. I think there was a hesitancy to throw people in jail or otherwise levy criminal penalties in open records cases, and it was never used. But now the law has some helpful sanctions provisions, and the first are in Section 1304. This section allows a party, if there's bad faith under the law, to seek attorney's fees and costs. Importantly, it can go both ways. So if a requester files an appeal in bad faith, the requester can also be sanctioned, although again, it's rare, to the same extent that an agency who blocks access in bad faith can also be sanctioned. And it's not guaranteed, it's discretionary from the court, but for more egregious cases, it's certainly there. Section 1305 also has two civil penalties. One is up to $1,500 a day, $1,500 a one-time penalty for bad faith, and there's also a $500 per day potential for a violation of a court order that has production. Again, these aren't huge amounts, and I don't know if they're necessarily enough to dictate agency action. So the real hammer you have under the law is ultimately that potential for fee shifting. These litigations can be complicated and specialized and expensive. So agencies can be on the hook for really serious sanctions if there is bad faith that can be established. And I think the most recent example of that sort of thing is a case I handled, and I mentioned at the beginning. It was the Uniontown newspapers versus the Pennsylvania Department of Corrections case. It started way back in 2014, so it's taken about half of my career to get the whole case through the Supreme Court and decided. But the newspaper, the Herald Standard in Uniontown, all the way back in September of 2014, issued a request to the DOC asking for information about certain diseases that were happening at SCI Fayette. The purpose of the request wasn't really to dig into the DOC and suggest that the DOC was harming people in the prison. It was actually to try to figure out whether that whole area surrounding the prison, the community, the whole area, which was situated between a fly ash dump and a water treatment plant that had its fair share of issues, whether that entire area was potentially facing an environmental and health crisis. The DOC denied access, the newspaper appealed to the OOR, and the newspaper ultimately won at the OOR level. What happened next was a little strange. The DOC provided some documents, it was piecemeal, it kind of trickled out, and then they said, we don't have anything else. That sent some red flags up at the newspaper, and that's when I got involved as counsel to figure out whether there was anything else, and we filed an enforcement action in the Commonwealth Court. This was 3 years of litigation in front of the Commonwealth Court. We took a ton of depositions, a ton of other discovery, and the case itself actually became newsworthy throughout the process, in addition to getting information responsive to the request. During discovery, I think we found out some really shocking things that ultimately became the basis for a bad faith ruling and a fees shifting issue at the end of the day. And the most glaring example was that we learned that the DOC hadn't even really considered the request or looked for information. It said they already knew what they had and gave us a prepackaged package of information that was provided to a different investigation. And the first time they had looked for documents and ultimately produced more documents was during the litigation and discovery. So the newspaper won disclosure of documents at the Commonwealth Court level, and also the more important ruling, at least from a legal perspective, was the newspaper won approximately $118,000 in fees. That was exponentially the largest right to know sanction in Pennsylvania history, and to our knowledge, really the largest of any kind of sanction in open records case that had happened in the entire United States. We went all the way up to the Pennsylvania Supreme Court. The case just wrapped in late 2020. And ultimately, I won't bore you all with what the statutory interpretation issues were, but the Supreme Court at the end of the day said, yes, you can have sanctions in this scenario. If an agency acts in bad faith under the right to know law, you can get sanctions, and fee shifting is the appropriate result. So it was an incredible case. It was a lot of fun. Certainly thankful to be a part of it, and thankful for a client who had the courage and ultimately the funds to fight that sort of thing. So with that, I think we're at the end of our time. Thank you for listening today. If anybody has questions, feel free to follow up with me or any of the presenters afterwards. We really appreciate it.
Thank you. The timing and promptness is very impressive of this group, and it was a really informative panel. So thank you very much. We are going to now. I'm going to move on to our last panel, which has a lot of information to cover, and it's talking about hot topics affecting the press, from slap to from subpoenas to slaps. So I'm going to pass the baton to Caitlin, who is our moderator, and thank you very much.
Thanks so much, Debbie. So yes, we are here with your capstone course at the end of your law school today, which is, you've heard a lot about how you can use the legal system to help your reporting. And now we're here to talk about how the legal system may affect you. And so that could be a subpoena, it could be a defamation case. And so my name is Caitlin Gurney. I am a partner at Ballard Spahr. I'm also a former Pennsylvania reporter myself. So I've been in your shoes, or many of your shoes. We will focus today on Pennsylvania, but we'll also look to the rest of the country. I know you're not all in Pennsylvania. I am so delighted to be joined with a tremendous group of panelists who also work day in, day out to protect you as journalists from these same subpoenas and defamation lawsuits. So we'll start with my colleague at Ballard, Max Mishkin, if you please introduce yourself. Want to give a little background, Max?
Sure, sir. I'm Max Mishkin. I'm an associate at Ballard's Bar based in the Washington, D.C. office, though from the Philadelphia suburbs originally, where my heart still resides. I practice exclusively media law, so I like to think anything that a journalist might get into trouble, defamation, invasion of privacy, or then anything that a journalist might want to get from the government in terms of freedom of information or right of access to judicial records.
Excellent. And now my former colleague, Alameen Sumar, now with the New York Times. Could you briefly introduce yourself?
Sure. Thanks, Caitlin. Hi, I'm a newsroom lawyer at the Times. I've been there since last year, and I work on a range of matters, everything from pre-publication review to litigating libel cases to FOIA to news gathering to the random hodgepodge of things that come up for an in-house lawyer. But my passion is really on work that helps reporters get information and protects them from frivolous lawsuits. Thanks so much for having me here, despite my lack of a Pennsylvania connection.
Absolutely. And then from the Reporters Committee for Freedom of the Press, a name that every journalist should have at the tip of their tongue, we have Paula Knudsen-Burke. Could you briefly introduce yourself?
Thanks, Caitlin. Nice to be with you all this morning. And I am the local legal initiative attorney for the Reporters Committee. And we have 5 of us throughout the United States in different areas. I'm here in Pennsylvania. We have lawyers in Colorado, Oklahoma, Oregon, and Tennessee. So if you have a question, no matter where you are, you can call the Reporters Committee hotline or email, and one of our lawyers will endeavor to get back to you. If it's here in Pennsylvania, I'll get back to you. And like Caitlin, I have also worked as a reporter, so I'm happy to be with you today.
Thanks so much, Paula. And then last but not least, we have Holly Lubart with you heard from our colleague earlier, with the Pennsylvania News Media Association.
Hi, everybody. So thank you so much for having me. I am the Vice President of Government Affairs for the Pennsylvania News Media Association. I advocate at the state capitol for over 300 print and digital media newspapers across the state. I've been with the association for about 4.5 years now. And prior to that, I worked in 2 administrations, the House of Representatives, and I also was a former reporter myself and started in broadcast television. So thank you so much for having me.
Thanks to you all. All right, to kick us off, we are going to start with a quick little overview of what protections you have in your back pocket as reporters. You might think it's pretty simple. Everyone knows about the First Amendment. Surely that's the end of it. And sadly, the answer is it's a lot more complicated than that. Yes, the First Amendment is here to protect you, but what protections for journalists are an interesting little interplay between state law and federal law. And those protections look a little different based on where you're working and where you might be facing either a subpoena or a defamation lawsuit. And so I will flip it over to Paula to go over the reporter's privilege under the First Amendment as it exists in Pennsylvania. And then also, like many states, Pennsylvania has a shield law. And so the Pennsylvania shield law and how that can protect you as well.
Thank you, Caitlin. And thank you to Debbie. She put in the chat our Reporters Committee website and hotline. And I am also going to drop in the chat after we finish speaking here a really important link on this very topic. So if you've ever experienced receiving a subpoena or a colleague has received a subpoena, you may be in the unfortunate experience that you know what we're going to talk about here. But this is important to know that every state has some protections. We're talking right now about Pennsylvania, but in the link that I'll drop for you, the Reporters Committee has a reporter's privilege guide that allows you to click on each state. So let's say you're a reporter who works in New Jersey and New York and Pennsylvania, you can compare the different states. So what I want you to take away from this overview of the reporter's privilege is that we have a statutory protection here in Pennsylvania that is called the Pennsylvania Shield Law. And we can also, as reporters, rely on the First Amendment reporter's privilege. Both of these provide broad protections to reporters who are subpoenaed for their notes, their documents, or to come to court and testify. Pennsylvania's Shield Law is an absolute privilege that will preclude the compelled disclosure of confidential source information. And separately, the First Amendment reporter's privilege is a qualified privilege that protects both confidential and non-confidential sources, as well as a reporter's resource materials, unpublished, and even sometimes published information. And we're going to talk about each of them separately. First, I'll talk about the First Amendment reporter's privilege. In order to overcome that privilege, the person who's serving the subpoena, and I'll give you just a couple examples. Maybe it's a criminal case here in Pennsylvania where the defense attorney thinks that you have notes that you took in your reporter's notebook that you didn't publish but may be helpful to exonerate their client. Maybe if you're a photographer, you took pictures and they think you have pictures that might help their client, or video. And so you may receive in the newsroom a copy of a piece of paper saying, if it's just you to come to court, it's a subpoena. If it's a subpoena for you to bring things with you, it's a different kind of subpoena called a subpoena ducis tecum. But that's what we're talking about, is cases where you get a notification saying, come to court or bring this information. In order to overcome that on the First Amendment privilege, the person serving that subpoena must show, one, that the information sought is crucial to the claims at issue, two, that there are no other alternative sources of information, that they've all been exhausted, and three, that the reporter is the only source of information. That's under the First Amendment privilege. Now, for Pennsylvania's own law, so if you're not in Pennsylvania, tune this out and click on our guide to look at your own state. But our Shield Law actually was first enacted back in 1937, and it's undergone a couple revisions, but it says, no person engaged on, connected with, or employed by any newspaper of general circulation, or any press association, or any radio or television station, or any magazine of general circulation, for the purposes of gathering, procuring, compiling, editing, or publishing news, shall be required to disclose the source of any information procured or obtained by such person in any legal proceeding, trial, or investigation before any government unit. So we have a pretty strong Shield Law in Pennsylvania that's designed to protect the free flow of information to the news media and help reporters protect the sources who are giving that information to them. So that's a very broad overview. I'm going to stop there. I'm going to drop this link in the chat. And then, Caitlin, I think it's back to you, and we're going to kind of blow it up and look at the national perspective.
We've promised breaking news, and indeed we have it in the world of subpoenas this year. As you've heard from Paula, the First Amendment nationwide protection for under pursuant to the reporter's privilege for news gathering information. And because we are going to talk about 4 nationwide organizations that have received, either had their data seized this year, or not actually this year, it came out this year, or subpoenaed. And you'll hear one of the reasons we're so protective of this is we're in the business of protecting this principle, the principle that your news gathering information is protected. And there was a lot of concern when the Trump administration came in because his first Attorney General, former Senator Jeff Sessions, announced that he was going to permit more subpoenas to news organizations. And so we were all expecting it. We were waiting and watching. And whether there would be a rollback of some protections that were instituted in the Obama administration under former Attorney General Eric Holder that said you have to go to the very top. You have to go to the Attorney General before you can subpoena members of a news organization's records. And we didn't think we'd seen a lot of action in that area, but in May and June of this year, it came out that 4 or 3 different news organizations had had records either seized or subpoenaed, all the way back dating to 2017. So back potentially, we don't actually know what all of these were related to necessarily, as you'll hear our panelists explain, but all the way back to former FBI Director Jim Comey, which appears to be, and the Russia investigation, there appears to be some similar common facts and common reporting related to that. So the 3 news organizations that had 2017 records sought by the federal government are the Washington Post, the CNN, and the New York Times. And then, intriguingly, all these prior subpoenas and seizures were announced in May and June, even though they were secured by the Trump administration. However, the Biden administration in February did indeed also issue its own subpoena to the news media, to USA Today, related to some shootings that occurred in Florida. So it's notable that several of these disclosures were made that were Trump administration related, but then the Biden administration had issued its own subpoena. So that is the stage set for you. And with that, I will flip it over to someone who was intimately involved in all of this, Alameen Sumar with the New York Times, which had not just a seizure of reporters' data, but also the head newsroom lawyer there, David McCraw, was actually subject to a gag order, just like the CNN chief counsel, David Vigilante. Alameen, can you talk to us a little bit about what went on?
Sure. Thanks, Caitlin. And yeah, looking back on it, it's funny because, going through March and April and May, I was sort of like, it's hard to tell what your colleagues are up to, the people you work with when you're working remotely. So I was like, well, there's not that much happening at the Times. It seems like this is a good time in legal. Things are a little quiet. And then, of course, this news comes out, and I was like, wow, David, I didn't know you've been dealing with this for months. But yeah, I got the news basically 6 weeks ago at the same time as the rest of the world, that the Department of Justice had not only sought email metadata for journalists at the Times, but also had obtained a gag order preventing the disclosure of that fact. So the way this happened, for the folks here who are not dialed into this stuff, the gag order was initially imposed just on Google. So the government got a court order under the Stored Communications Act against for New York Times records for production by Google, and it also obtained a gag order, which was also issued under the Stored Communications Act, that prevented Google from disclosing that fact. And then Google did something remarkable that we don't maybe necessarily expect tech companies to do. It said, we're not going to comply with this order unless you unless you allow us to tell the New York Times Deputy GC David McCraw about it. And the DOJ acceded to that and allowed Google to do that. David then, in turn, fought for the right to tell a handful of people at the company and outside lawyers about the order. And then the company entered into negotiations with the DOJ. It was a very small number of people. I mean, it was basically David, Diane Braden, who's the GC, A.G. Sulzberger, the publisher, and Meredith Levine, who's the CEO, and like literally 3 outside lawyers. So no one else knew about it. And then there was lots of back and forth, letters exchanged, negotiations. The Department of Justice ultimately withdraws its request for the email metadata, which is a huge victory. But it was a truly shocking episode for a number of reasons. One of which was what the basis for the gag order appears to be. So the order was based on the court's finding, and we know this because we have a copy of the order, and presumably that finding was based on a DOJ representation to the court that, and this is the court's words, there is reason to believe that notification of the existence of this order will seriously jeopardize the ongoing investigation, including by giving targets an opportunity to destroy or tamper with evidence. Why was this crazy? Well, because the apparent investigation was a matter of public knowledge, and in fact was one that the New York Times had reported on. The DOJ, it appears, we don't know this, and Max will talk about our efforts to unseal documents so that we can know more about this, but it appears that the DOJ was looking into classified information reported in a 2017 Times article about Jim Comey's handling of politically charged investigations during the 2016 presidential campaign. And the Times had reported on this investigation in January of 2020. So it's truly remarkable. We don't know what the DOJ said to the court. We don't know what the basis for the finding was, but it's very hard to understand how this makes sense. So the DOJ, as I said, didn't get the email metadata. That was a big victory. Credit to David and our outside lawyers for that. They did, however, get phone records for 4 Times employees for a period in 2017 related, it seems, to the same investigation. We think that these are basically metadata and phone stamps, the kinds of things that you see on your phone bill. And we're going to talk about a little later about the sort of national response to this from the administration, from Congress. But I think, the takeaway here is clearly that, the guidelines on their own are just not enough, because it's going to be up to the administration, whichever administration is there, to decide whether they want to comply with the guidelines and to decide how broadly to interpret, the guidelines provisions, which are, in some cases ambiguous, and turn on the facts of the case. So there's definitely sort of work to be done here to remedy these issues in a systemic way.
And just to underscore one of the things Alameen said is the actual request from the government went to Google rather than the Times itself. And so we have national news organizations with tons of resources that are finding themselves in a difficult position, which is if they host their own data, then they'd be victim potentially or just subject to attacks from hackers globally and the like. But then if they go for a more secure route, they're not in control of the data that, in fact, the DOJ was seeking. And so while we're seeing that Google, as Alameen said, took the extraordinary step of notifying the New York Times, other organizations, phone companies and the like, have simply just treated this like any other request and turned over the data. And then you only find out, in this case, 4 years later after the fact, and it's this big shock. And there is indeed a national outcry that Alameen will address shortly. But Max Mishkin has been involved in some efforts to try and figure out the source of this mystery, the cause of these subpoenas and seizures. And Max, could you talk a little bit about what you're doing on behalf of the Times?
Sure. So, we, Ballard regularly represents the Times in a number of cases, and like the rest of the world, we were in the dark about the gag order until the news broke. And obviously, everybody who works with the Times was like Alameen, surprised that these people that we work with were subject to this secret gag order for so long. We were glad to get a call from David McCraw saying basically we want to know, and the public has a right to know, what DOJ was telling this court in order to justify the kind of extraordinary and, by all appearances, unjustified gag order, and asking us, would we please seek access to those records? So I know that you had a previous panel today on the right to know law, and so I will take just 30 seconds to mention, if you don't know, and it was one of the right to know laws and the Federal Freedom of Information Act, generally speaking, apply to the executive branch. In some states, they apply to the legislative branch. Federal, they don't apply to the legislative branch. Generally speaking, they don't apply to courts. if you want judicial records, you need to seek them from the court themselves, and you sort of have two routes to do so. The first is what's known as the common law right of access, which is when lawyers refer to the common law, they basically mean lots of decisions pile up over time, and eventually you sort of come up with a rule based on how the decisions have come out. And so starting in the 70s, the US Supreme Court really recognized a common law right of access to judicial records and proceedings. That is to say, briefs, exhibits, judicial opinions themselves, the public has a right to see them based on the fact that since time immemorial, courts have been open institutions. Starting in the 1980s, the Supreme Court recognized that that right also extends out of the First Amendment itself. And so you will often hear media lawyers refer to either the common law right of access or the First Amendment right of access. Common law right of access is a sort of wishy-washy balancing test. The First Amendment right of access is very powerful. It's, if the First Amendment right of access attaches to records, it can be very hard to justify keeping them from the public. And so these records, which are basically a motion or two motions, applications that the government filed with the court seeking both the production of the underlying records from Google and then imposing a gag order. We have argued in motions that we filed with the district court are subject to both rights of access, common law and constitutional, and there's no possible way now that so much is in the open and the public has such an incredible need to know this information that the government can justify keeping this information, that is these applications, secret. And in terms of, to go back to Caitlin's, we promised breaking news, not 24 hours ago, or maybe 48 hours ago, in the Washington Post's, the similar request to the Washington Post, the district court just at the government's request unsealed unsealed with redactions the applications that have been put in that case, with a really good opinion that says, in a nice little snarky move, that quotes an opinion that then Chief Judge Garland, now Attorney General Garland, had written, talking about the importance of public access to these sorts of records. It's a nice signal that the courts are taking this this access issue seriously. We submitted our access motion on June 8th. It is still pending. These things, unfortunately, though, there's all kinds of good case law about the right of access is contemporaneous, and any delay in access is a denial of the public's right to know. As a practical matter, these things take time, and if the government wants extra time to respond, they often get it. Watch the space for more about what the government told the court, as we hopefully either get them to voluntarily cough it up, or we get a judge, and it's before Judge Boasberg to order them to do so.
And thanks, Max. And so we talked about how the New York Times, the Washington Post, and CNN were all subject to Trump era subpoenas and seizures, but there was a fourth subpoena, and that was to USA Today. Max was also involved in that case. And Max, could you tell us a little bit about that Biden era subpoena and what happened with that?
Yeah, so it's an interesting case in part because, it timing wise, it was wild that this was happening while these sort of stunning and unprecedented gag order news stories broke. But on the other hand, it's a bit of a different flavor, which is to say that USA Today reported on a shooting that took place in Sunrise, Florida in February, where FBI agents serving some kind of warrant were shot and killed, and the suspect then apparently killed himself as well. USA Today published a news report about that, and they subsequently received by fax an administrative subpoena from the FBI asking for IP addresses and other sort of identifying information about who may have read that news report during on a particular day at a particular time. So this is not a request for journalist sources. This is a request to identify the readers of journalists' reporting, which raises a different issue under the First Amendment, but very much an issue under the First Amendment. In fact, we cited prominently, and we first wrote USA Today, Gannett, first tried to figure out if they have the information, which is always a good first step, because if you don't have information that the government wants, the best answer is, I'm sorry, we can't help you. But if you can't make that great argument, you can generally speaking move to quash a subpoena. And the question is how you do that when, a shield law, which is to say, you have a right to protect your sources, doesn't necessarily apply to a subpoena asking you for your readers' information. But there's very good case law going back to the Red Scare, basically, that government demands for lists of your readers itself creates a First Amendment harm by chilling readers from from being willing to read things that they might be worried that the government is going to turn around and ask for. We have this great language from Justice Douglas from 1953, where he says, if the lady from Toledo can be required to disclose what she read yesterday and what she will read tomorrow, fear will take the place of freedom in the libraries, bookstores, and homes of the land. That 50-year-old case law has been applied more recently during the Ken Starr investigation. The special counsel sought records of what books Monica Lewinsky had bought from a Washington, D.C. bookstore, Kramer Books, and the government ultimately got the records from Ms. Lewinsky herself. She gave them over, but the court had ruled that in order to justify that kind of demand for readership information, you need to sort of go through the same similar exercise of it needs to be incredibly important. You need to show that you can't get it from somewhere else. Basically, the First Amendment is important in protecting reader privacy. So we got no response to our response to the FBI on behalf of Gannett, and so we were forced to go to court. We moved. It was also assigned to Judge Boasberg, busy guy. And while the motion was pending, all the news broke about the gag order stuff, and the president came out and said subpoenas to journalists are improper, basically. So we had the enviable position of watching the executive branch sort of turn against the arguments it might have made against our motion before they even had the chance to make them. And lo and behold, in the face of our motion, cooler heads must have prevailed at the Department of Justice. They admitted they did not, in fact, need the information, and they withdrew the subpoena. So that day was saved.
And my favorite part of this particular chapter of in what we're talking about today is the USA Today lawyer found out about this administrative subpoena in COVID era at a fax machine that no one uses, no one checks, in a musty office that no one's been in for like over a year. And so we think of the FBI as all powerful, but sometimes the tools they use kind of blow your mind, like a fax machine. But there has, with all of these disclosures, so for large news organizations all facing governmental intrusion in some way or form, there has been a national outcry from First Amendment advocates across the country. And Alameen, can you talk, and one thing I should note is there were also seizures of sitting congressmen's data as well, so by the FBI. So all of these disclosures come out at once. The Biden administration has changed its approach with some significant lobbying. And Alameen, can you tell us a little bit about where the state of things are with that?
Sure. And just before I do that, I want to underscore, why the situation at the federal level is so worrisome. And that is because we have no federal shield law, right? There are First Amendment protections, there are common law protections that the courts recognize, but these vary, based on the jurisdiction you're in, just like the sort of state shield laws that we've been talking about. And so the only overlay you have on the common law First Amendment protections are the news media guidelines, which the news media has fought very hard to negotiate over the years. Changes have been made, but as this case illustrates, it is really up to the administration how they're going to interpret them and whether they're even going to enforce them. And so, that leads to the question of, well, how are we going to, improve the situation? So in the immediate aftermath of, some of these revelations, there were actually some mixed signals coming from the Department of Justice, and it almost seemed like for a minute that the Biden administration was sort of standing by the actions of the DOJ attorneys. And then, as Max said, the president makes this seemingly offhand comment to a CNN reporter that it was simply wrong for the government to seize the records of reporters, and his administration wouldn't do it. And I think the reaction of most people was just like, oh, I guess that's just Biden, making it, an off-the-cuff comment that he might regret later, and we're just waiting for people in his administration to walk that back. But they actually really haven't done that, to our surprise. And the signals coming from particularly Attorney General Merrick Garland have been very encouraging. So he has now met twice with representatives of news organizations about their concerns. I think a lot of those discussions have been off the record, but what's been clear is that they are very sensitive to the concerns that the media has raised, and do want to take meaningful action to address them. They've stated publicly, Attorney General Garland has stated publicly that the DOJ will change the news media guidelines. We'll see how exactly that's done, but they're sort of going to meet periodically to continue talking about this. And at least on a personal level, the Attorney General has expressed support for a federal shield law, which would, give real teeth to the protections in the guidelines. And alongside that, we're also seeing some action in Congress, which is encouraging. So about 2 weeks ago, the House Judiciary Committee had a hearing on leak probes and prosecutorial abuse. And there were legal experts, including from Ballard Spahr, who testified about the government's abuse of gag orders and service providers. They made recommendations about legislation that would give journalists greater protections and curb the government's power to issue requests for information and gag orders. And there seemed to be, at least, on some of these issues, bipartisan agreement. So that was nice to see. At the same time that happened, certain members of Congress introduced, an actual bill, a shield law called the Press Act, which would address some of the concerns raised by news organizations. That has happened before, and the bill has sort of just died. It's unclear what will happen with this one, but there is bipartisan support for this, and so I think we're all hopeful that the Biden administration will throw its weight behind this and try to get something done fairly quickly.
Thanks so much, Alameen. So we're going to switch gears and address breaking news in the other way that journalists can get brought into the court system, which is a defamation case. So the First Amendment is, again, your big protection, but defamation law is a creature of state law. There's state statutes in every state that indicate how the different parameters for how plaintiffs can sue journalists for defamation and other publication-related torts. The most famous case, of course, however, is not from state court and is from the U.S. Supreme Court, which is Times versus Sullivan. And it created the standard of actual malice, which I'm sure you all have heard of, which is when you're reporting on public officials, and later that was extended to public figures as well. The plaintiff needs to establish actual malice, which is knowing that you knew something was false at the time you reported it and you published it anyway. However, Times versus Sullivan, despite its very long vintage, has come back in the news recently, both from members of the Supreme Court and with some influential circuit court judges. Max, can I tilt it over to you for you to talk about what we're seeing?
Sure. So, as a young media lawyer, one of the things that my colleagues told me was that basically, it's great that the First Amendment is in our case is, generally speaking, a thumb on the scale, is what we will often say, right? And that the biggest example of that thumb is the actual malice rule. And for two generations of media lawyers, it has been settled law, and in fact has only expanded. Times versus Sullivan applied to public officials. That is, it was a police commissioner in Alabama. Over the decades since, the Supreme Court extended the actual malice rule to public figures, that is, people who occupy a significant position in society and have access to the channels of communication, and created a category of limited purpose public figures. You might be a public figure in only one particular thing, but if the speech about you is about that one particular thing, the actual malice rule applies. And so, sort of with some, minor tide coming in, tide coming out, speech protection has increased as the scope of the Sullivan Rule expanded until, well, I should say that, the Sullivan Rule is alive and well, but there are suddenly people who are calling for its revocation, and some of those people sit on the United States Supreme Court. So starting a few years ago, in the McKee versus Cosby case, which was, a case where one of Bill Cosby's, alleged victims sued Bill Cosby because his lawyer accused her of lying about about her victimhood. It is an interesting sort of precursor to Me Too issues involving defamation and sort of attempts to silence whistleblowers. But that case went up to the Supreme Court. The Supreme Court declined to take the case, but in sort of a added on opinion explaining why they weren't going to take the case, Justice Thomas basically questioned whether the Times versus Sullivan Rule should persist, and he came up with a sort of historical originalist argument that says that Times v. Sullivan was a policy decision, not a constitutional decision, and that should be revisited. For a couple of years, us in the media bar sort of treated that as a idiosyncratic, one-off thing. But then, earlier, I guess just weeks or days ago, in another decision, deciding not to take up a case, but then two justices, Clarence Thomas, now joined by his colleague Neil Gorsuch, wrote to say again that Times versus Sullivan should be revisited, if not dramatically pared back, arguing that in this day and age, arguing that it was never, it's ahistorical, and in this day and age when everybody has access to the media, how can you say who's a public figure, and that the sort of the pragmatic need for the actual malice rule doesn't apply anymore. Like I said, as we sit here today, Times versus Sullivan is the law of the land. But those of us who practice media law day in and day out are certainly keeping an eye on. Plaintiffs' lawyers have certainly picked up on this, and you will now see, I think, what would have been sort of unheard of 10 years ago. You'll now see in a opposition to a motion to dismiss for lack of actual malice, plaintiffs' lawyers are making the argument that Times v. Sullivan should be overruled, and they're preserving it for appeal in case it gets up to the Supreme Court. So, again, sort of watch this space. Something that we did not think needed to be relitigated is potentially at risk.
Indeed it is. And well, it's we've seen nationally in the wake of this, and some of this is President Trump and his call to open up libel laws, which of course are a creature of state law, but and some of this we've seen has come to the Supreme Court, but nationwide in states that haven't seen it for years, we're seeing public figures and public officials sue press and ordinary citizens who happen to speak out on social media in a way that we have never seen before in any state. Well, and one of the exceptions to that is Pennsylvania. So we're going to bring us back to Pennsylvania, where lawsuits by public figures and public officials has sadly been the norm for years. And Paula is going to talk to us a little bit about Pennsylvania procedure and Pennsylvania defamation law. And one of the things that's been really successful in other states in terms of reducing the number of defamation cases you see, and above all, the length of those and expense of those defamation cases, which is something called an anti-SLAPP law. Paula?
Thanks, Caitlin. So for those of you who live in a state or have worked in a state that has a robust SLAPP law, anti-SLAPP law, Guess what? We don't have one here in Pennsylvania, unfortunately, although Holly is going to talk to us a little bit later about efforts to try to beef up our SLAPP law. And I told Caitlin and my colleagues on this call, I always have to kind of spell it out to myself. What is SLAPP? It's an acronym, Strategic Litigation Against Public Participation, SLAPP. So basically, we think of it like a big company suing a smaller entity like a homeowners association or a small news outlet or a blogger. And often it's because the smaller entity has been writing or talking about something that the big entity has been doing. We see this a lot in development. Let's say there's a developer doing something, and in order to stop the public discussion, they file suit. Now, many of these lawsuits are without merit. And so what an anti-SLAPP law does is it gives the people who have been sued for talking about legitimate public issues a quick out. And in Pennsylvania, our quick out SLAPP suit is only limited to environmental issues. And this very narrow interpretation of SLAPP law in Pennsylvania means that if there's a lawsuit filed against a news outlet or a blogger or a citizens group for anything else outside of the world of environmental issues, they cannot rely on Pennsylvania's anti-SLAPP law to help them get out of that lawsuit. And one of the reasons why SLAPP suits are really helpful is because they do give an avenue to assist the entity that's been sued with getting out. And some of the ways that that happens is through an early motion to dismiss, a stay of discovery, and discovery is the back and forth exchange of information. That can be really time consuming and expensive. A SLAPP law would also allow for a quick appeal and an award of fees. So if a big company files a meritless lawsuit just to stop discussion, having a broad SLAPP law really deters these baseless lawsuits and lawsuits that are aimed at stopping free speech and kind of limiting a discourse, especially on something that a company that has a lot of money and a lot of lawyers can engage in litigation for years. And right now, let's say a small news organization is sued by a big company and they say, you've defamed us with your coverage. Really the only recourse is to engage in preliminary objections and litigation that can go on and on and on. And there are very limited resources for a lot of news organizations and small entities that find themselves in that position. So I will drop another link from the Reporters Committee, which is our compendium of SLAPP lawsuits across the country. So you'll find a reference to Pennsylvania's current SLAPP suit. And I think we're going to hear about the status of attempts to increase that. It would be really helpful for journalists and citizens in Pennsylvania if we could get more protection. And I'm looking forward to hearing from Holly about how things stand.
Absolutely. But before we get to Holly, I'm going to briefly, well, first a quick programming note, which is we're nearing the end of our panel. And if you have any questions, please go ahead and put them in the chat and we will do our best to get to them with the remaining bits of our program. And we'd be delighted to hear from you. But before we hear from Holly about the status of where things stand in Pennsylvania, I'm going to flip quickly over to Alameen to tell us about some anti-SLAPP successes in other states. Traditionally, members of the news media have never been advocates in legislatures. We don't think our place is to be in legislatures, it's to cover legislatures. But that is really changing. And we're seeing a lot of news media organizations, including the Times, advocate for anti-SLAPP protections in different states, including New York. Alameen, can you tell us a little bit about the New York law and your efforts elsewhere?
Yeah, Caitlin, that's exactly right about the New York law. We joined an effort put together by the New York News Publishers Association to push this through the legislature, which was ultimately successful. And you're right, the Times is very, say, reluctant to get involved in lobbying efforts because, we think that compromises our coverage in some cases. We don't think it's really our role, but this is something that we think is really important because, especially in the last few years, we've just seen a lot of politically motivated, frivolous suits that are an attempt to shut us down, to stop our reporting, to prevent the public from knowing information that it should know. And so we think that a law that advances those goals is one that we should throw our weight behind. And the early indications in New York are that the law has actually been very successful. There have been a number of decisions now where courts have found that the law applies retroactively. So we've actually had a lot of case law. And by and large, courts are dismissing cases. Also, not so much in federal court because at least on procedural level, the statute does not apply there. But even in those cases, we think we can get attorney's fees because that is a substantive provision that applies in federal court. But in the state courts, we've seen a lot of successes, courts getting rid of cases at the very outset. Maybe the only suit where the anti-SLAPP motion was denied is actually one of ours. We think the judge got it completely wrong. The case is brought by Project Veritas, which tells you exactly what you need to know about this case. But we are appealing. We're confident that we're going to prevail on appeal. But even in that case, we think that the anti-SLAPP statute gives a strong basis to tell the judge, you should hold off on discovery until after this appeal is resolved. And we think that will work. So, the New York law is a huge success for us. We'd like to see this done in other states. And just like the Pennsylvania law, the New York law used to be very narrow. It used to be about permitting and zoning, and that's the only context in which it applied. And now it's much broader and basically applies to any matter of public interest. And we've seen a huge change. So it's a very encouraging sign, and I think it's an indication of how it could change things in Pennsylvania if there were a broad statute.
Thanks so much, Alameen. And so in addition to New York, another Eastern Seaboard state that has a brand new anti-SLAPP law is Virginia. And hoping to close the gap in between is none other than our Holly Luber. Holly, can you tell us about Pennsylvania's efforts?
Sure, absolutely, Caitlin, thank you. So I wish I had breaking news to share in Pennsylvania on what's going on with SLAPP, but the legislative process is often a very long one. And it certainly has been with SLAPP. We have been working at PNA, even before my time at PNA, to advocate for SLAPP legislation and to expand the law to protect not only journalists and media organizations, but citizens from being silenced from these SLAPP lawsuits. And they're eventually dismissed and decided in favor of the defendants. But unfortunately, by the time that happens, they can cost thousands of dollars. And I actually have an example of a guy that reached out to me. I'll talk about that a little later, but they can cost thousands of dollars in legal fees and take an immense amount of time. And that just creates a really significant financial burden and emotional toll on people and news organizations. So the unfortunate thing is that many news organizations are forced to kind of gauge the risk, even associated with an article. They have to estimate the cost of a lawsuit. And as Paula mentioned, there's a lot of smaller newspapers that are financially strapped. Do we really want to take this on? And we kind of believe that is silencing the First Amendment. And obviously that's a problem. Over 30 states have a broad SLAPP statute, and they've been supported from, groups all over the political and business spectrum. So in the past, Senator Farnese, a Democrat from Philadelphia, introduced Senate Bill 95, and we had great success there. It passed in the Senate in 2015, almost overwhelmingly, 48-1, and in 2017, it passed 42-8, but it always died in the House. So we kind of took a different tactic, and we secured a House sponsor. So Representative Diamond, a Republican from Lebanon County, introduced House Bill 95 on the House side. So that bill was referred to the House Judiciary Committee, and we asked the chairman to hold a hearing on the bill. Now, hearings are not always held on bills. However, it gives legislators, kind of a better idea and understanding of what, these pieces of legislation actually are. So the committee held a hearing in December of 2019. So P&A, Melissa from the last panel testified, as well as 2 media law attorneys. One of Caitlin's colleagues testified, as well as numerous other stakeholders, and it went very, very well. And one of the interesting things that I'll point out is that we had to deal with a current sitting senator at the time who had filed SLAPP suits against women accusing him of sexual misconduct. So we had discussions back and forth, and at the time we made a strategic decision to keep that example out of the testimony, and we focused on other things. But it's just kind of interesting when you're dealing with the political world and legislators, kind of the strategic decisions that come along with that. But of course, 2020, COVID happened, shut down nearly any movement on legislation other than dealing with the pandemic and with COVID related issues. So the legislative session ended in 2020. Now we're into the new legislative session. Representative Diamond is going to be introducing a bill, and Senator Farnese has retired. So 2 new Democratic senators have sent out a co-sponsor memo to introduce the bill. Last year, the Uniform Law Commission, a group that basically comes together to kind of study the laws and determine which areas of the law should be uniform, they passed the Uniform Public Expression Protection Act. Another tongue twister. New York, as Alameen had also mentioned, passed a SLAPP statute. So there was kind of renewed energy in Pennsylvania, to keep this moving forward. So we've been working with numerous stakeholders, media lawyers, the ACLU, Americans for Prosperity, and those 2 organizations are completely on different sides of the political spectrum, Broadcast Association, Bar Association, and others, to move the bill this session. So the coalition reviewed the prior legislation as well as the uniform legislation and determined what language we wanted to present to the legislature this session. So we presented the new language. We're working with the bill sponsors, their respective staff, and Judiciary Committee staff. The main issue that we're actually up against at the moment is the Pennsylvania Chamber of Business and Industry is opposed to the legislation, and they wield a lot of power at the state capitol. So the interesting thing is no other state has encountered this. So we believe it's because their members use SLAPP suits. So we're working to try and get them to neutral to get this bill moving forward. That's kind of the biggest, issue that we're seeing right now. And because of that, we also met with the House Majority Leader to discuss the movement of the bill. We're going to be meeting with the chamber next month. But the legislative process is a very long one, and legislators deal with hundreds and hundreds of issues. So our goal is to really show them that these suits threaten the First Amendment. We want to make this simple for them to understand and provide them with real life experiences, because anyone, as expressing their First Amendment rights can get a SLAPP suit filed against them. And we wrote about the issue in an op-ed, and I had a gentleman reach out to me. And he's being sued in federal court over, get this, his review of a Spartan mosquito eradicator. I know. So he said, quote, "I am $100,000 in the hole already and getting desperate." So he asked for recommendations for a pro bono attorney. So literally, this is a problem, and it can happen to anybody. The key is really getting legislators to understand that this is a problem and why it needs to be fixed sooner rather than later. So there's always twists and turns in the legislative process, and it's not a simple one, but we really remain optimistic on getting this one to the finish line. So thank you.
Thank you, Holly. So yes, watch when the legislature comes back. Let's watch what happens and see whether this might be our year. Fingers crossed. So it's been our great pleasure to be here with you today. talking about the different ways that journalists can find themselves involved in the court system, whether that's a subpoena or a defamation lawsuit. We are here protecting you, doing our best, whether that's in the court system, advocating before the Attorney General, or in Holly's case, before the Pennsylvania State Legislature. So wish us luck, and in the meantime, continue your great reporting, and we have your back. Debbie, any final notes from you?
Just want to say this day or morning was amazing, and thank you to all the panelists. It was informative, enjoyable, and we look forward to holding this again next year in some different topics. So your thoughts, everybody who's participated will get a survey. Please give us suggestions for topics that you want to hear. And thank you, and have a great day.